together every other year when it's held. And so far, we have been the only mother-daughter lawyers.
Okay.
So everybody gets a kick out of that, which is really, really fun.
I gotta run downstairs a minute. Okay. You need anything?
I'm good.
Okay, okay.
Mic check, mic check. 1, 2. Audio check from 310. Mic check, 1, 2. Mic check, mic check. 1, 2. Audio check from 310. Mic check, 1, 2.
Bring some stuff on.
Okay.
Morning.
Check one, check two.
Hey, John, I can hear you. Good.
Yep, same.
Okay.
Levels are good.
Okay, very good. I set up agenda room. They got a meeting. It was at 9, but I think they pushed it back to 10, but shouldn't have any problems up there either.
Is that the Zoom?
That's a WebEx.
Go.
It's with David Spratt. I don't remember, so I guess it's water or something.
Okay.
So,
Sounds good. Yeah, you sound great.
okay, awesome. Thanks.
All right, later.
Oh, they're coming in this morning.
Yeah.
Hey, that door,
It's locked?
yeah,
Oh.
The badge wouldn't even
the
let
badge
you.
wouldn't even let us in.
Yeah, we're both
Which is
trying
odd.
to.
That is very odd. I don't understand that one.
It turns green.
For a split second, and then it doesn't open.
Okay.
I wonder if something's,
I don't know about that.
I'm gonna run upstairs anyway. I'll run up and
Okay.
I'll get the key and I'll tell Dawn.
All right,
It
thanks.
might be-
Well, look, it's fine, I'll get over here. I'll get you some.
So Jackie, I hear you're in practice with your mom, is that right?
Um, we're not in practice together, but she does appear here on behalf of, well, I guess it's MEC now, it used to be Mudmuck, or MPUA.
Okay.
And so she's in a different law firm, but similar areas of the law.
Oh, well, interesting.
Yeah, it's nice. It's, it's, we talk some shop, when
Yeah.
we can, and it's good to be able to pick her brain. And,
Oh, yeah, that's nice. Very cool. Let's see here. And I think we went through your PowerPoint, right? It was all there. Let me think, complicated, straight PowerPoint, right?
Yeah, that's it. Yeah, no effects.
Okay.
Yeah.
That's the best.
Yes, I agree.
Keep it simple. Nancy, is that right now? Is that working okay now?
Yeah, you know, we changed up the access because we realized it was open to public counsel. And I guess we changed it so it was just adjudication,
Yeah. I don't know. I
but we
think
probably
that's fine.
should change that one back so staff can.
So, yeah.
I just had to unlock the,
Back,
yeah, they just were.
Okay.
So I've got the keys right now.
Okay.
Good morning.
Good morning, how are you?
Good.
Good.
This is just a empty envelope. Well, have you found out yet who is replacing Jenny?
You're looking at her.
Good, good. Congratulations. Very deserving.
Nice to meet you.
I was talking to
And you're, for
Judge
Evergy.
Mark,
Yeah.
yeah.
Nice to meet you.
He was
I've
only,
only, like, you've been on Zoom.
Yeah.
But nice to see you in person.
I know, yeah, just putting faces to names at this point.
Yes, exactly.
Such a weird world after COVID.
It is.
His, we're gonna kind of, work around his return tomorrow.
Oh, okay.
His party is tomorrow at 1. so-
Oh, it's tomorrow, okay. Well, maybe I could come back because I have a,
Yeah, if you're in the neighborhood.
yeah, Board of Nursing home administrators here tomorrow at 11. They probably won't.
We'll be in, 470, which is across from that.
Very nice.
Also what? Fire alarm testing tomorrow, but we've moved it up earlier, so hopefully.
did.
You can get in
I was gonna say, I have that for you, and
Okay.
then I have this for you as well.
that. Okay, the exhibits, okay.
Uh-huh.
All right, you want me to take those?
Yeah, if you're ready for them now,
Okay.
we can
All right.
make sure there's nothing extraneous in there for you. Nope, this should be all the
Just-
files.
Yeah,
Right
just
there.
set them right there. That-
Okay.
That's good, thank you.
No problem.
Bev,
Yeah.
If they're pre-filed, you may not get a copy, so.
Okay. You know what, I will just, should I give them to you?
Yeah.
Okay. Let me see. I think this was not, this wasn't that the exhibit was, yeah, okay, then you can have these all. I'm happy not to have exhibits.
And if you need those for your witnesses or something, let me know. we can go ahead and go on the record. Good morning. This is the Public Service Commission's hearing in EA-2023-0328. My name is Nancy DePel, and I'm the regulatory law judge assigned to this matter, which is captioned in the matter of the application of Evergy, Missouri West, doing business as Evergy, Missouri West, for the permission and approval of a certificate of public convenience and necessity, authorizing it to purchase, own, operate, maintain, or otherwise control and manage an existing wind generation facility in Oklahoma. I welcome you all here. I also have three of the commissioners on the bench with me, Commissioner Roop, Chairman Roop, and Commissioner Holzman, and Commissioner Kolkmeyer. And we may have Commissioner Coleman on the phone. So we're going to begin this morning with our entries of appearance, and I will begin with the company.
Good morning. Roger Steiner, Jackie Whipple, Carl Zobrist, and Jim Fisher appearing for the company.
And staff,
Nicole Mers on behalf of staff.
the Office of the Public Counsel,
Anna Martin and John Kleiser on behalf of OPC.
and Renew Missouri.
Elisa Greenwald on behalf of Renew Missouri.
I will ask anyone on the WebEx to be sure and mute your phones unless you are speaking. Like I say, I think maybe Commissioner Coleman might be our only person online today, so we have a full house for a change. Also, anyone in the room, if you could silence your cell phones or other devices, that would be appreciated. We pre-marked exhibits, or each party pre-marked their exhibits, and we'll pretty much follow that and add to those lists as we go as needed. And the witnesses we will take in the general order that was proposed, unless someone lets me know that there's a conflict or a reason to do otherwise. Few other scheduling issues. I would like to begin, if we go into a second day, I'd like to begin in the morning at 8:30 because we have, we'll need to break about 9:45 for the commission's agenda and perhaps reconvene again at like 10:30. Provided the agenda has concluded. And then I would like to tomorrow take a late lunch, maybe breaking at 12:30 and taking a little bit longer lunch break for a retirement reception for Judge Woodruff.
Judge, may I
Yes.
interrupt really quickly?
Yes.
Sorry. I'd emailed counsel, but Renew's witness, James Owen, has had a conflict come up that will keep him until being here at 1:30 today.
Okay.
So I'm not sure if we'll get to him by then, but if we do get to him before then, would it be okay to move him down in the witness list?
That will be fine.
Thank you.
Are there any other known conflicts or issues with anybody's schedule?
I do not think it'll be an issue today, but Claire Eubanks is not available today.
Okay.
If we get that far in the schedule, that would be amazing, but I'm not sure if it will be a conflict, but if so, if she could be granted permission to just go tomorrow, we'd greatly appreciate it.
All right. Any other scheduling issues? All right, that sounds good. The only other scheduling issue is first thing in the morning, and it's been moved up now, so I don't think it will conflict, but at 7 a.m. tomorrow morning in the building, there will be a fire alarm testing. So just so you know, if you're in the building in the morning that early. Okay. Well, I believe do we have any other preliminary matters? Don't see anything, so we can go ahead then and begin with opening statements, and we'll begin with the company.
May it please the Commission, Judge. My name is Jacqueline Whipple with the law firm of Denton's U.S. LLP. Today, Roger Steiner, Carl Zobrist, Jim Fisher, and I will represent Evergy Missouri West, Inc. in this proceeding. This case involves Evergy's request for an operating certificate of convenience and necessity to own, operate, and maintain the Persimmon Creek Wind Farm, an already operational facility located in Oklahoma. The company's application represents the first time a public utility has requested an operating CCN under Section 5 of the Commission's newer CCN rule. It is undisputed that the company has met the only 4 requirements of Section 5 by filing A, a description of the asset, B, the asset's value, C, the purchase price and plans for financing the operation, and D, the plans and specifications for the asset. I will discuss this further in a few more moments. Importantly, Section 5's requirements are not detailed and are meant to be easier to fulfill than any other type of CCN in the Commission's rules. Both a construction or line CCN in Section 6 and a service area or retail CCN in Section 4 mandate the filing of a multitude of plans, studies, notices, and other requirements. However, an operating CCN is requested for assets that are already providing service. The company will be presenting 3 witnesses to explain the application and to answer your questions. Matt Doherty, Evergy's Director of Regulatory Affairs, provides the overview of the company's application and how it meets both the CCN rules requirements and the Commission's traditional standards for approving CCN requests as necessary or convenient for the public service. Evergy's Vice President of Renewables and Assistant Treasurer Jason Humphrey provides a detailed overview of the project, its favorable economics, its operation, and the transaction to acquire it, as well as the competitive renewable wind energy request for proposal process that led to the selection of Persimmon Creek. Evergy's Vice President of Strategy and Long-Term Planning, Kayla Messamore, describes the company's integrated resource planning process and how it too supports the company's request, as well as the value of Persimmon Creek to the company and to its customers. The Persimmon Creek Wind Farm is a 198.6 megawatt wind generating facility with 80 wind turbine generators. It spans approximately 17,000 acres and is located in parts of Woodward, Ellis, and Dewey counties in western Oklahoma near the Panhandle. The wind farm became commercially operational and in service more than 4 years ago. Evergy Missouri West signed a term sheet and letter of intent to purchase Persimmon Creek on June 27, 2022. And executed a definitive purchase agreement on August 8 of 2022. This membership interest and purchase agreement, aka MIPA, allows Missouri West to purchase the shares of the company that currently owns Persimmon Creek for approximately $245.7 million, plus working capital adjustments and adjustments for production tax credit value, both of which will be finalized at closing. This commercial agreement was reached through an arm's length, competitive RFP process, including comparative valuations of other similar projects that have been offered for sale. Persimmon Creek was the lowest cost bid with the lowest levelized cost of energy, which Mr. Humphrey describes more in his testimony. The Persimmon Creek Wind Farm is generating renewable energy today that will provide renewable energy certificates and is 100% eligible for federal PTCs. Time is of the essence for Evergy to receive prompt approval of the application, so the company will own a new long-term, low-cost wind generation facility. The purchase of a wind facility has been a part of the company's Preferred Integrated Resource Plan, or IRP, filed with this commission on June 10, 2022. The commission found that this IRP complied with the Chapter 22 IRP rules. The project provides a valuable addition to the company's portfolio because of its long-term, low-cost energy, its renewable capacity, and its ownership structure. The IRP thus shows the project will produce economic benefits for customers, including reduced costs over the 20-year planning horizon, unlike any alternative option. As identified in EMW's change in plan filing made on September 27, 2022, and as testified by Ms. Messamore, EMW's capacity need is at least 170 megawatts in 2024. Persimmon Creek is assumed to provide at least 20 megawatts of this accredited capacity. In addition, the acquisition pricing of this project is locked, whereas if the company were seeking a construction or line CCN, such new project or new build would be subject to escalating prices, as well as economic and supply chain uncertainty. However, the time for the company to close the commercial agreement and complete this acquisition is running out, as witness Humphrey testifies. At the same time, the company must obtain reasonable financing in the current economic climate, where inflation continues unabated and interest rates are on the rise. Just a few weeks ago, the Federal Open Market Committee of the Federal Reserve Board, quote, decided to raise the target range for the federal funds rate to 4.5 to 4.75%. In a February 1, 2023 press release, the Federal Reserve Board press release stated, the committee is strongly committed to returning inflation to its 2% objective. Further, having EMW operate the Persimmon Creek Wind Farm aligns with Missouri's renewable energy policies, including the Renewable Energy Standard, or RES, law, and provisions of the Plant in Service Accounting, or PISA, law. The addition of Persimmon Creek to EMW's resources will provide environmental benefits as well as a diversified energy resource to serve the community as Evergy transitions its generation fleet to achieve the target of net zero emissions by 2045, with an interim goal of a 70% carbon reduction in such emissions from 2005 levels by 2030. In approving CCN requests, the Commission follows Section 343.170.3 and determines whether CCNs are necessary and convenient for the public service. As the Missouri Court of Appeals made clear when approving this Commission's grant of a CCN for the company to build its first solar plant, this necessity or convenience standard has never meant that a CCN must be essential or absolutely indispensable. Instead, a CCN must simply be of benefit to ratepayers, an improvement justifying its cost. The company has more than amply met this standard in this case. Here, the weight of the evidence establishes that the company has a clear energy and capacity need, and Persimmon Creek is the least cost wind resource available. Now that elevated gas and energy prices are expected for the long term, EMW needs additional energy resources to serve as a hedge against increasing market prices. Of course, obtaining additional capacity and reducing the company's market dependence in this economic climate will directly benefit customers. For context, EMW's load is twice the amount of energy that it has to offer into the market. In the previously low-cost environment, EMW could buy energy cheaper than the costs associated with adding resources. That is no longer the case and is not expected to be for the foreseeable future. The company's IRP shows that acquiring Persimmon Creek will result in $130 million in benefits to EMW's customers. Adding Persimmon Creek to EMW's generation portfolio is also consistent with prior positions taken by the Commission, its staff, and public counsel that have encouraged the company and its predecessors to invest in its own generation, especially renewable resources, instead of relying on power purchase agreements and the wholesale SPP electricity markets. Renew Missouri is supporting the company's request. And there is no dispute in this proceeding that the company has met Section 5 of the CCN rule. There is also no dispute that the company has both the financial ability and the qualifications to operate Persimmon Creek. Staff and public counsel, however, have raised concerns about granting the CCM at this time, based largely on misinterpretations of the need and economic feasibility Tartan factors. Staff and OPC have argued that the project is not needed since the company is not literally being forced to add resources by regulation or external resources. Staff's and OPC's overly narrow approach would put customers at risk, exposing them to rely only on the wholesale market to meet long-term needs. This approach must be rejected if the Commission desires to move forward with transitioning Evergy's generation portfolio from old fossil fuel units to newer, clean, renewable technologies such as wind and solar generation, as Ms. Messamore describes in her testimony. The same is true for the economic feasibility of the project. Staff and OPC theorize that some unspecified project at an unspecified time might provide unspecified lower costs or additional benefits. But conjecture is not the standard for determining economic feasibility. And it is undisputed that high-capacity factor wind generation from western Oklahoma is one of the cheapest forms of renewable energy in the United States today. After the competitive RFP process, Persimmon Creek was selected because it had the lowest levelized cost of energy of all projects. The Persimmon Creek wind facility is attractive compared to alternative available projects from a permitting and supply chain perspective as well, because it is already operational with the lowest congestion risk for delivery to Missouri customers. Persimmon Creek is also one of the most advanced and efficient wind generating facilities now in operation, with a proven operational aggregate net capacity factor, or NCF, of approximately 50% over the past 4 years, as Mr. Doherty describes. As a necessary result, and because all of the other Tartan factors are satisfied, the proposed Persimmon Creek acquisition would promote the public interest. Staff and/or OPC have proposed 4 conditions if the Commission grants the CCN, 1 of which is largely acceptable and 3 of which must be rejected based on Commission precedent. Staff first recommends that the Commission order that the in-service criteria contained in attachment SEL-2 to Sean Lange's rebuttal testimony are appropriate for use in future cases to determine whether the Persimmon Creek project is in service. The company finds staff's in-service criteria to be generally reasonable. The company does have a concern with the potential expense of recertifying an asset that has already been performing an SPP service. The site was commissioned with an independent engineer, GE, and the site owner in 2018 and continues in service today. However, the company would work with staff to implement the in-service criteria as the commission deems appropriate. As for the second proposed condition, staff recommends the CCN should be conditioned on any future monies lost or increased expenses due to compliance with future laws or regulations or future environmental compliance. And staff states that these future compliance expenses or losses should not be borne by the ratepayers, but instead solely by the shareholders. Staff's recommendation is unprecedented and far out of bounds of the traditional regulatory construct in Missouri. As the Commission knows, customers under Missouri law and customary practice pay for the cost of a utility providing service to them. Shareholders provide the capital for the service and are entitled to the opportunity to earn a reasonable return on their investment. The Commission will make a determination if Persimmon Creek is in the public interest, as it has done for all of the company's other generating assets. And the Commission does not use hindsight to review the prudence of decisions to acquire generating assets. If the Commission were to accept staff's proposed condition, it would clearly break the historical regulatory compact between public utilities and their customers, and would condition recovery of the asset provided in a CCN upon speculative market events in the future. Such a decision would have far-reaching impacts on the regulation of public utilities in Missouri. Importantly, Persimmon Creek is in full environmental compliance with all laws and regulations today. The potential for a rule or law to change in the future is not a reason for shareholders to bear that risk. Over the life of an investment, numerous laws may change. The utility is, of course, required to comply with the law of the land at all times, and as the law evolves, the utility must make investments to stay compliant. If the law were to change, shareholders would play their role to provide capital for investments, which would then be subject to review for prudency in a future rate case. For the third condition, staff and/or OPC recommend that the Commission order Evergy Rest to track the PTCs, the production tax credits, accrued on its books, or its revenues, so that they are available for the Commission's consideration in Evergy West's next rate case. This proposed condition is inconsistent with the Commission's previous decisions on tracker requests and accounting authority orders. The Commission has held that trackers and other deferrals should be infrequently approved and rarely utilized. The Commission has held that trackers should apply to only extraordinary items and not to routine costs. Trackers should apply to costs that are volatile in nature. Neither the production tax credit nor E&W's revenues meet any of these requirements. So staff's and OPC's recommendation violates past practice, supported and advocated by the staff and ordered by the Commission in prior cases, which were affirmed by Missouri courts. Staff also has not disputed that E&W customers will immediately begin receiving benefits of this zero energy cost resource flowing through the FAC prior to the asset being recovered in base rates. For the period between the acquisition and the next rate case, the PTC will be an offset to the regulatory lag that E&W will incur until such time that Persimmon Creek is fully recovered in rates. This is an appropriate and balanced treatment, fully supported by the existing FAC tariff, the PISA statute, and historical rate making. Fourth, staff and OPC recommend that the Commission hold Evergy Missouri West ratepayers harmless if the costs of Persimmon Creek were ever to exceed the market revenues and ratepayer realized benefits. Most importantly, This hold harmless proposal and the second proposal requiring shareholders to bear solely the risk of future losses or expenses would result in EMW being unable to pursue the Persimmon Creek acquisition. Under staff's recommended conditions, EMW's return on its investment could be determined by SPP wholesale energy market conditions that are outside the company's control. If SPP wholesale energy revenues, in combination with the Persimmon Creek tax credits, were below what was needed to recover all costs, EMW shareholders would be required to absorb the difference. This would be unreasonable, unlawful, and confiscatory. Unlike an independent power producer operating a merchant plant, the utility is providing a service for the benefit of customers, which in turn is based on a variety of factors evaluated by the IRP per commission rules. These conditions do not exist for other Evergy Missouri West generating resources that have already been determined by the commission to be necessary for service to customers. If taken to its logical conclusion, staff's argument would indicate that many of EMW's existing resources should not be a part of its fleet, and EMW should simply procure all of its energy from the SPP market for EMW customers, notwithstanding the pricing and reliability risk that would come with that decision. This would not be a reasonable approach from the customer's perspective. These last proposed conditions are ill-conceived and should be denied. Finally, the evidence establishes that authorizing EMW under Section 393.190.1 to complete the asset transfer and merger described in the application and in Mr. Humphrey's testimony is not detrimental to the public interest. In sum, the CCN rule is met, and the evidence more than establishes that the project is necessary and convenient for the public service. Persimmon Creek is the right project at the right time. It will meet clear energy and capacity needs, and clear benefits will immediately flow to customers in Missouri. Thank you.
Right, thank you. Are there any commissioner questions for Evergy?
Yes.
Mr.
Thank you, Judge.
Chairman?
Good morning.
Good morning.
What does the company estimate would be the cost incurred to recertify the existing? And if you don't know that, that's fine, just
I know
whoever-
that Jason Humphrey knows the answer to that question. I could confer.
No, I just
Okay,
letting you know that I would like to know that answer at some point.
understood.
Thank you.
Thank you.
Mr. Commissioner Holzman?
What kind of congestion is in that area of the project, and what kind of transmission would be available to move that power throughout the SPP footprint?
That is also going to be a question for witness Humphrey. If you like, I could,
I'll wait.
okay,
Thanks.
thank you.
Any other commissioner questions? All right, thank you
Thank
very
you.
much. Renew Missouri.
Good morning, and may it please the Commission. My name is Elisa Greenwald, and I'm here on behalf of Renew Missouri. Over the past 10 years, investor-owned utilities in the state of Missouri have made massive investments in wind energy. And while environmental concerns have been at the forefront of conversations surrounding clean energy nationally, the largest driving factor behind these investments has been the clear economic benefits that wind delivers to utilities and their customers. But beyond simply the economics, wind energy benefits the public through cleaner air, healthier people, and more competitive businesses. In fact, throughout the past 10 years, we have seen Commission precedent build upon these concepts to conclude one thing, that wind generation promotes the public interest. And the public interest is a key consideration for this commission, as it has broad discretion to grant a CCN when it determines that the public interest is served. While staff's characterization of this factor severely limits its application, the public interest is not constrained to only looking at physical need. It is also important to note that the larger benefits provided by wind generation are not abstract concepts that are entirely unquantifiable. For example, the integrated resource planning process considers environmental costs that are incurred by fossil fuel generation and avoided by renewables. Through its IRP planning and a range of other analyses, Evergy has determined that the Persimmon Creek Wind Farm is the best resource to serve the needs of its customers. This process requires in-depth modeling and provides opportunities for stakeholder feedback to be incorporated into ongoing planning. That the benefits of wind energy and other sources of renewable energy are reflected in IRP results should be an expected outcome and should certainly not be a basis for devaluing the IRP as a planning tool or discrediting Evergy's analysis. We encourage the Commission to consider the credible evidence put forward that establishes what we know to be true, that wind generation promotes the public interest through benefits to customers, the utilities, and the state as a whole. With these factors in mind, we encourage the Commission to approve Evergy's CCN application. Thank you, and I'm happy to answer any questions.
Are there any commissioner questions? Thank you, Ms.
Thank you.
Commission staff. Oh, I'm sorry, was public counsel next? I must have written it down wrong. Public counsel then.
Just very briefly, I'm actually going to give an introduction for our newest attorney before allowing her to give her openings. So to that extent, and for the record, John Kleiser on behalf of OPC, it is my privilege this morning to introduce to you Ms. Anna Martin, the newest member of the OPC. She is a native of Missouri. She hails from Webster Grove. She graduated in 2014 from the Missouri State University with double bachelor's in English Lit and Latin, and then went on in 2018 to get a degree in law from the University of Missouri at Columbia. She has served 3 years with the Department of Social Services, serving first as a public hearing officer and then as a managing attorney. We are very proud to have her join our team, and with that, I'd like to turn it over to Ms. Martin to provide the OPC's opening statements. Thank you.
Thank you. And welcome, Ms. Martin.
Thank you. I'm loud enough that I can do it from here, but I'm going to go to the podium. Also very short. Okay. So, good morning to the Commission, and may it please the Commission. My name is Anna Martin, and I am here on behalf of the Office of the Public Counsel. So, in 2001, Evergy West entered into a power purchase agreement, or a PPA, for Gray County Wind Farm. To date, Gray County Wind Farm has lost ratepayers over $25 million. In November 2012, Evergy West entered into a PPA for Ensign Wind Farm. To date, Ensign has cost ratepayers $61+ million. Osborne Wind Farm has cost PPA, or the Osborne Wind Farm PPA has cost ratepayers over $20 million since that PPA began in December 2016. Rock Creek Wind Farm was entered into for a PPA in August 2017, and it has cost almost $28 million for ratepayers. November 2018, they entered into the PPA for Pratt Wind Farm, and that has since cost almost $10 million for ratepayers. They did enter into one positive money-making venture, I suppose, for Prairie Queen Wind Farm, and that has since made about $2.7 million for ratepayers since 2019. Evergy West keeps claiming that they are entering these PPAs due to favorable economics and for reasons that are not related to RES or renewable energy standard compliance. These PPAs have cost EMW customers over $141 million so far. And it will get worse. In 1970, George Eckerloff wrote a famous paper about the detrimental effect that information asymmetry has on the value of goods in the market. In that paper, Eckerloff refers to high-value goods as peaches and low-value goods as lemons. Over 22 years, Evergy West has entered into 6 PPAs, insisting they were peaches. Over 22 years, Evergy West has repeatedly chosen lemons, and their lemonade stand has cost ratepayers over $141 million. Now, Evergy West is insisting that Persimmon Creek is a peach. In reality, Persimmon Creek is a wind farm with almost 5 years of generational and financial losses. Persimmon Creek is a lemon, and Evergy West knows it. Today, my central question for the Commission is how much more money is Evergy West allowed to lose for captive customers? Before, EMW was buying lemons that they believed were peaches. Here, they know that Persimmon Creek is a $250 million lemon, but this purchase will benefit Evergy West shareholders. And that will be at Missouri's captive customers' detriment. The Public Service Commission staff and the Office of the Public Counsel are united in our belief that Persimmon Creek is a bad bet. This wind farm is uneconomic. It will not help with capacity, and it does not even increase the amount of renewable energy in the SPP market. OPC's expert witnesses, Jordan Seaver and Lena Mantle, will be available for any questions that you have about why Persimmon Creek is a bad wind farm to purchase. Until then, I implore the Commission, look at the CCN request with a critical eye. I implore that you ask more from your public utilities. I ask that you require more protection for captive customers. And I ask that you deny the CCN. Thank you. And if you have any questions, I am here.
Thank you. Are there Commission questions? Mr. Chairman?
Thank you, Judge. Good morning. Welcome.
Morning.
Great job. Thank you.
Thanks.
Appreciate it. I'm sure you're nervous, but you did great. So when you're rolling through the different costs to ratepayers, how are you calculating? What are you comparing that to? Other generation costs, or how are you coming up with your?
With the negative and positive
balances?
amounts. If you speak to Lena Mantle, she knows a lot about this stuff. I'm sure you're very aware, but she has been keeping track of this for years. So yeah, that's how we calculate it.
All right, but I'll just, and then you'd stated that this only benefits shareholders. And is that argument just because it adds to rate base, or how do you determine that this is only a benefit to shareholders?
So if you look at, and again, this is going to be something that Lena and Jordan are able to speak about a little bit more than I can, but if you look at, there's production tax credits, there's, if you look at ratepayers needing to give shareholders not only the amount back for pardon me, the asset, but also you have that profit that is built into how much they owe, then ratepayers are getting that as well as the PTCs. That they, because this is not going to be entered into rate base for 1 to 4 years. So.
Okay, thank you very much.
Yeah, of course. Are there any other?
Are there other Commission questions? Don't see any. Thank you.
Thank you, and I do apologize, Mr. Bell, for interrupting.
And now staff.
Good morning. May it please the commission. This is Nicole Mers on behalf of staff. And staff is here today to urge you to look past the catchy slogans, the self-fulfilling prophecies, and the false sense of urgency, and look at the actual real data in this case. This is not staff being against renewables. It is not staff being against long-term resource planning. And it is definitely not staff holding an impossible standard of need. What staff is saying that in this case, that this specific project should not be approved. This project fails to meet the need threshold, as there is not a capacity need. And if there was such a need, the generation attributes and the potential for heavy curtailment make this project unsuitable. The capacity issues that have been explained by staff witness Jay Lubert also significantly impact the economic benefits of this project. The negative pricing seen in the historical operation of this project, which we do have the 4 years of data for, it makes the economic benefits to customers, that threshold, another Tartan criteria that is not satisfied. As the project will not cover its cost, it also cannot act as an effective hedge. And that substantially increases risk to ratepayers. That means the project is not in the public interest. So it fails the Tartan test. Now, staff is not saying that there is no project, let alone no renewable project, that could provide the benefits that Evergy desires or provide an effective economic hedge for ratepayers. But staff has not been presented with that project. Staff has only been presented with generic data, as Brad Fortson will explain, to support a generic wind project that became a self-fulfilling prophecy due to Evergy's own choices and self-selected inputs. Furthermore, upon receiving specific data for Persimmon Creek, it further highlights the flaws in both the specific and generic assumptions used for both the IRP modeling and the CCN case modeling that Evergy has presented, which has also been noted in numerous staff witnesses' testimony in this case. So I'd like to give a high-level overview of these fundamental flaws and how these flaws mean that the Tartan criteria have not been met, and so this project should not be approved. Please, please ask staff witnesses over these topics. It's very, very easy for the deluge of information in this case to muddy waters. One may think that, well, if Evergy has looked at all of these things, doesn't that therefore mean that analysis was rigorous? Doesn't it therefore mean that they've looked at most situations and scenarios and have accounted for these situations? But staff's witnesses can walk through how Evergy's analysis fails on several key parts. The first flaw, as I mentioned, that staff finds with this case is with the need aspect. Now, parties that are supporting this application are quick to point out that there have been several cases where need has not been narrowly defined as absolutely indispensable or required, but just an improvement justifying its cost. And as I'll explain a little bit later, and Jay Lubert can testify to, staff does not believe that this project does justify its cost. But furthermore, allowing a monopoly utility to add generating rate base or assets to its rate base, untethered to ratepayer need, could result in substantial increases in rates and unnecessary risk for ratepayers, with the only upside being for shareholders and their ability to earn a return on those assets. Demonstration of need can act as an upper limit to the amount of rate base additions of generating resources, which is necessary since Evergy Missouri West shareholders would not carry the risk that the Persimmon Wind project is ultimately uneconomic. Again, that risk would be borne by ratepayers. SPP does not view Evergy West on a standalone basis for resource adequacy, but even allotting the most charitable view towards Evergy on an individual basis shows an alleged IRP capacity need of 170 megawatts in 2024. This project will only provide 20 megawatts, 20, to fulfill that alleged need. Evergy West, with or without this project, will still need to acquire 2 combustion turbines, each 237 megawatts, Brad Fortson and Claire Eubanks will provide an in-depth analysis on these points and can provide explanations. Brad Fortson is also the manager of the Energy Resource Group for staff and oversees staff's work on resource planning, so he's an excellent resource if you have questions on resource planning, IRPs, or any of those matters. So not only does this project fail to meet a physical need, it fails to meet the hedging need that has been described by Evergy. As staff witnesses Claire Eubank and Jay Lubert can explain, in order to maximize the mitigation of exposure to high market energy cost, the energy production of a resource would need to be highest when those nodal market prices are high and ratepayer demand is high. Persimmon Creek fails on both ends, as it generates most at night when prices are low or even negative, and also when ratepayer demand is very low. Next, Evergy's analysis fails to show this project will be economically feasible for ratepayers. In staff's analysis, it is very unlikely that revenues would cover the cost of the facility. Locking ratepayers in to paying for assets that are primarily justified by faulty economic analysis, which also does not fulfill a clearly identified need, is an unnecessary risk to ratepayers and benefits only Evergy Missouri West shareholders. Jay Lubert can also further explain how Evergy's analysis significantly overstated the production capacity and understated how often negative prices will be incurred. In fact, it's my understanding that in Surrey Battle, Evergy's response to staff's argument about the negative prices was that staff was actually too optimistic and that Evergy would be willing to incur even greater negative prices than staff analyzed. And what staff analyzed was, the actual operations of Persimmon Creek over the last 4 years. So my understanding that negative pricing risk would be due to the production tax credit, which then makes it even more unreasonable that Evergy, if this project is approved, would incur those negative prices to flow to customers for the sake of that production tax credit offset. But then Evergy proposes to keep that offset for the benefit of shareholders. This is why Matt Young has proposed a tracker for the production tax credits to ensure that if this project is approved, as much harm to ratepayers can be mitigated by capturing the upside of the production tax credits to mitigate that downside of negative revenues and losses. Mr. Young can also explain how this is an appropriate mechanism, as Evergy will be receiving PISA treatment on this plant. And I don't want to get into potentially confidential numbers in an opening, but my understanding is that the value of the PTCs that Evergy would keep due to the beneficial regulatory lag and without the tracker outweighs on an order of magnitude double to triple, in millions of course, for shareholders to the amount of negative regulatory lag that they would experience from that 15% of PISA not being all captured, and then the O&M. Finally, for public interest, staff cannot say that the project is in the public interest and meets the Tartan criteria upon staff's weighing of all the factors. This is also because, as proposed by Evergy, all the risk of failure of the project to perform is assumed falls on ratepayers, and Evergy is not only insulated from those risks, but from most of the risk and costs associated with regulatory lag. So in conclusion, staff would encourage the commission to remember these facts. The historical revenue of Persimmon Creek indicates that market revenues are unlikely to exceed the revenue requirement associated with this project. This means that if this asset is included in rates, ratepayers are expected to pay more for the asset through rates than the offsetting market revenues for Persimmon Creek. Fact 2, the SPP node for Persimmon Creek has experienced increased hours of negative pricing since 2018, which will result in negative market revenue or added cost if the asset generates in those hours. Fact 3, if the alleged need is to meet SPP resource adequacy's needs of Missouri West, Persimmon Creek is a poor solution on a $1 per kW accredited basis. Remember, it's only 20 megawatts for the entire $250 million that would be spent for this case. Fact 4, Persimmon Creek is not likely to be a great hedge against exposure to market energy cost. Energy produced from Persimmon Creek is relatively low when the load of West ratepayers is high. Market prices generally are elevated during times of peak consumption, which is usually in the summer months, in part because of the increased demand for, by use of air conditioning. So Persimmon Creek is unlikely to take advantage of those elevated market prices by producing energy outside of those peak consumption time periods as wind produces higher at night, and mostly at night. There's also the curtailment potential in this case, which would further exacerbate production during summer months when it's most needed. Finally, Evergy Missouri West's IOP analysis drastically underestimates the propensity for negative LMPs, market prices, at the Persimmon Creek SPP node. This is exacerbated by the fact that Evergy's utilization of the capacity factor in both its IOP analysis and its CCN case analysis, its LCOE, least cost of energy analysis, they do not take into account the fact that after the asset is no longer producing production tax credits, the asset would not be generating during those negative pricing. So this drops the capacity factor. Staff does have some conditions if the commission would decide to grant the CCN, which we hope you don't. Brad Fortson and Jay Liebert can explain some of the modeling related conditions and requirements that staff has suggested. Matthew Young can explain the request staff has made regarding the tracking of the production tax credits. And Sean Lange can explain staff suggestions in light of the very possible curtailments Persimmon Creek could experience. So I am happy to try to answer any of your questions that you may have, and if not, maybe point you to the appropriate staff witness.
Thank you. Mr. Chairman?
Thank you. Appreciate it. Good morning.
Good morning.
This is a 10,000-foot view question for staff. Is a theme emerging from staff? When I look back at the previous Ameren case on the solar farm and now this case, that if there is a capacity need and the project put forth does not solve that entire need, then that shouldn't be brought forward.
No, I don't think that is necessarily an accurate summation or explanation of where staff's coming from, and I can maybe put forth a little bit of a unique perspective on it because for most of the CCN cases that staff has been a part of in the past, and many of those we have recommended approval of, I don't think that we're being, contrary to what other parties may say, inconsistent with that. I think that when you are talking larger projects, more cost, and with the fact that we have had both MISO and SPP come to the commission and speak on reliability projects, or reliability issues that the grid may sustain, plus after what we've seen in Storm Uri, the staff is just, when there is not the definite, we have res compliance we must meet, or gaping shortfalls in energy production where load cannot be met. That we're just saying that perhaps a higher threshold needs to be looked at, that it's not enough to just say, well, we need experience running this kind of plant, or people like solar and they ask us for solar. The ratepayers are on the hook for this for the life of the plant. And as I mentioned, we're not saying that wind in general would be, that every single wind project that could have been proposed would have not been appropriate. But just due to the economics and the changing situations with reliability, with the coal retirement, that we really want to make sure that customers are getting their bang for their buck. Now, if Evergy was coming in and proposing the and hopefully staff doesn't hold me to this later, but, I think that if it was a situation where this was just 20 megawatts of wind or 30 megawatts of wind with the CTG or some combination that really would get at, actual reliability issues or actual need, which if you talk to some of staff witnesses, I'm not sure that we're seeing that right now for Evergy, but I do think that, it's not, if it doesn't fulfill all of your requirements, that we would say no. I just think that it needs to be, when you're looking at it in combination, a economic choice, especially if you're justifying it for economic reasons, which Evergy has in this case.
And so kind of following up on that, you had stated that, if this was approved, that the company would still need to build 2 combined cycle natural gas plants to fill their need. So would staff be arguing that the company should build 3 combined cycle natural gas plants and not explore wind farms anymore, or what is the thought process there?
Sure. And that's a very fair question. So, and again, I think that both Brett Fortson, Jay Libbert, and Claire Eubanks would have much more technical and better response to this. But
well, I'm asking those questions so that they can think about these ahead of time. So I know you're the staff attorney.
Why is she
you
trying
can't
to
argue all
answer
their
it?
points, but
just to give I think maybe a summation or a sneak peek of what I think they may say. From my understanding from the IRP and looking at both historical practice and how the SPP looks at Evergy in the market, on a combined basis, there is not a need where Evergy would not be meeting capacity resource requirements. So they wouldn't need to build a third combined cycle. They wouldn't need to build a solar facility or a wind farm for those reasons, because on a combined basis, they're meeting their requirements. And in fact, up until very recently, they, when looked at on individual basis, kind of had a bilateral agreement with themselves to meet those capacity shortfalls where, some of the capacity on Metro's books was, moved to West, and I believe that there were some monetary exchanges, but it was a much, much lower cost, which again gives staff the concern that, if that kind of deal was okay up until now, why is that no longer sufficient until you need to actually come in and build the capacity because you've maybe retired some more coal plants or you've got more load. I'm sure that they can explain much better, but that is my very, like you said, 10,000-foot view on where we would be on that.
all right. My last question, and shifting gears a bit. Based on what I've read in testimony, I understand, staff feels that the company has, their inputs for the RFP and stuff was kind of, you don't agree with of that. Would you go as far to say that the company chose this site and then created the RFP and designed it in order so that the site was selected?
I have to be careful with trying to make intent, but I will note, and I think it is in the procedural schedule where you can see kind of maybe not the impetus behind it, but the outcome of it is that it does feel more like it was a solution in search of a problem. Staff did encourage, because of the passing of the IRA and some of the concerns that we had noticed when we were beginning our review of the case. So we had said, can you guys take a closer look? Does the IRA impact things? Are there other projects now with the IRA that might be more economical? Can you take a second look? And that was the hope for supplemental direct. Now, in Evergy's, and I don't want to speak on their behalf, but judging from the testimony, the supplemental testimony, they filed that their second look was, yeah, it's still great. But I think that from what we saw then, and Brad Fortson is definitely a great witness for this, and what we're seeing in the IRP, it does seem like it was we were nudged to this project, perhaps.
Okay, thank you very much, appreciate it.
Are there, Commissioner Kolkmeyer?
Yes, thank you, Judge. Good morning.
Good morning.
The company, Evergy West, claims says that the nameplates has a capacity of 198. Mm-hmm. You're using 20. Can you explain the difference?
I can try to, and that
It's a
would
huge
probably, yes,
difference.
yes, it is. It'd probably be a better question for both Jay Lubert and Claire Eubanks, but I think from a high attorney point of view, not high attorney, high level attorney point of view, it is both, that discrepancy is both due to what SPP will accredit wind generation for.
Okay.
Which is not going to be full nameplate capacity. I think it's, I'm going to look to Jay to see if he'll nod, but 20 to 30%? 10? 10. It's 10, much lower. It's 10%.
That number is real close to 10.
Yes, yes, so it is, yes, 10%. And I think that if you ask questions of Mr. Lubert and Ms. Eubanks, that they can explain not only does SPP accredit those capacity, those types of resources at a much lower rate, which impacts when you're searching for capacity, but that we have further concerns that even what is perhaps SPP accredited or what is predicted may still not come to fruition with, after those PTCs expire, you're not going to be producing to get those PTCs, so you have no incentive, hopefully, to produce when there are negative hours. And there also is and I don't want to get into highly confidential information, but Mr. Sean Lange can explain too that we do have fears that that capacity factor could be impacted by potential curtailments in the future.
Thank you.
Mm-hmm.
I just have one question. Which staff witness should the commission pose questions related to Ms. Mazamore's schedule KM-2, which was attached to her supplemental direct?
Okay, KM, unfortunately, I do not have the knowledge of what the schedules contain memorized, but I think it's probably a safe bet that it would probably be Jay Lubert on those things,
I'm sorry, I didn't write down the name.
It is okay, and if it winds up not being Jay, we can definitely make sure that we note that to you guys, but he's kind of our ringer, so, really put him to the test, guys.
All right, and then you mentioned two acronyms. I just wanted to make sure that we had clear. IRA?
It's the Inflation Reduction Act.
And LMP, you kind of explained, but
Locational marginal pricing.
Thank you.
You for the assist.
Thank you.
All right. Thank you all.
Okay, that concludes opening statements. I think we'll take a short break before we begin with the witness testimony. So let's break until 10:15. We can go off the record. Okay, let's go ahead and go back on the record. All right, we're back on the record after our break. We are ready to begin with Evergy's witnesses. If
Yes,
Evergy-
yes, Judge, we would like to call Matt Doherty to the stand.
Mr. Doherty, do you solemnly swear or affirm the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. If you could spell your name for the court reporter, and then,
Matthew Doherty, M-A-T-T-H-E-W-D-O-R-I-T-Y.
thank you. Go ahead, Mr. Fisher.
Thank you, Judge. Please state your name and address for the record, your business address.
Matthew Doherty, 1200 Main Street, Kansas City, Missouri, 64105.
Are you the same Matthew W. Doherty that caused to be filed in this case direct testimony, which I'll tell you has been marked as Exhibit 1, and supplemental direct, which has been marked as Exhibit 4, and sir rebuttal testimony, which has been marked as Exhibit 7?
I am.
Do you have any changes or corrections that we need to make to your pre-filed testimony?
I do not.
If I were to ask you the questions that are contained in those testimonies, would your answers be the same, and are they correct to the best of your knowledge and belief?
Yes.
Your Honor, with that, I would move for the admission of Exhibits 1, 4, and 7, and tender Mr. Doherty for cross-examination.
Would there be any objections to Exhibits 1, the direct testimony, 4, supplemental direct, or 7, sir rebuttal testimony of Mr. Doherty? Seeing none, I will admit those exhibits. All right. We'll go by the order of cross, like I say, set out in your list that you provided. So begin with Renew.
Yes, just briefly, thank you. Good morning, Mr. Doherty.
Good morning.
Are you familiar with staff's position on whether Persimmon Creek serves the public interest?
I am.
And what is that position?
They say that Persimmon Creek does not serve the public interest.
And in your professional experience, has the public interest been constrained to only looking at physical need?
No.
What else has the commission considered when looking at the public interest?
The commission has broad discretion to look at whether the service is necessary or convenient in the public service. And so it doesn't have to be necessity. It has to look at whether it's an improvement to justify the cost.
And do you believe that Persimmon Creek does promote this public interest?
I do.
Thank you.
Is there anything from Office of the Public Counsel?
Not at this time. Thank you.
Staff?
Good morning.
Good morning.
On page 3 of your sir rebuttal, you state that staff's position puts ratepayers in more risk. Is that accurate?
Yes.
Is it your understanding that the Evergy wind PPAs have lost over $40 million in the last 10 years?
I would defer to company witness Kayla Messamore to address any of those allegations.
Okay. Are you familiar with Evergy's securitization case, EF 2022-0155?
Yes.
Okay. I'd like to mark an exhibit. I think it, oh, okay. Oh, she handed me those. Sorry. It would be staff exhibit 107, I believe.
Yes, that's the number I have.
It's all right.
Sure.
I got it. Yeah, I'm good.
Yeah, 5, please. Okay. And since we'll be entering it into the record, I won't have you read the entire exchange into the record, but do you recall that exchange in the hearing with Mr. Reed, I believe, who was a consultant for Evergy, Missouri West?
I do not, but I can read it.
Okay, yeah, no, take your time.
Okay.
Okay. So in that discussion with an Evergy, Missouri West consultant in the financing case, do you agree that that consultant, Mr. Reed, is explaining Evergy's interactions with the SPP market and that it buys and sells all that it needs for its load from SPP? Is that a fair summation of the
Yes.
few pages? Okay. And would you agree that he states that since you essentially buy all of your needs from SPP, whether you're long or short of generation, that doesn't, the fact that you're long or short of generation doesn't affect reliability? I believe that is on page 260 in response to a question from Judge Clark. Would you agree that that is his response?
Yes, that's his response.
Okay. And that he also states a little above that the market was fully capable of meeting energy needs to ensure reliability of deliveries to the customers would be maintained. Is that also?
That's what he states.
Do you recall when that case was heard?
Within the last year?
Okay. And have there been any significant changes to SPP market protocols that would make those descriptions inaccurate?
If you're referring to the witness's testimony, No, not in that context.
Okay, and it, again, just to clarify, this was a consultant for Evergy
Evergy.
testifying on behalf of Evergy. Okay. I'd like to go ahead and offer Exhibit 107 into the record at this time.
Would there be an objection to Exhibit 107, which is a portion of the transcript from EF 2022-0155? That's pages 256 to 261.
Judge, I just stated it is hearsay, but you can take it for whatever it's worth.
So that's not an official objection?
I won't object.
You won't object?
I will not.
Okay. Is there any other? Seeing none, then I will admit Exhibit 107.
Putting that to aside and turning again to your rebuttal testimony, you discuss extensively staff's request for the trackers. Is that a fair characterization of your rebuttal?
Yes.
And I believe on page 23 of that rebuttal, you restate a commission prior opinion that, in reference to the 2014 case, that Evergy, at that time KCPL and GMO, requested trackers for transmission fee expense, property tracker expense, and a cybersecurity expense, and that the commission's denial found that the broad use of trackers should be limited because they violate the matching principle, tend to unreasonably skew rate-making results, and dull the incentive a utility has to operate efficiently and productively under rate regulation approach employed in Missouri. Is that an accurate restatement of your testimony?
That's correct.
And do you agree with the commission then on that the broad use of trackers violates the matching principle, unreasonably skews rate-making results, and dulls incentives?
We agree that the commission has repeatedly made that determination.
So you agree the commission has made that determination, but that Evergy may be bound by it, but doesn't itself agree?
Well, this is quoting a case that KCP&L brought before the commission advocating at that time for the trackers, but there's been repeated commission orders that speak to the commission policy as it relates to when is an appropriate use of a deferral mechanism.
So do you agree with the commission that trackers violate the matching principle?
Well, we have made the case in the past that there are circumstances to use trackers, but the commission has repeatedly determined, as we've laid out in the testimony.
So you can't say if you agree or disagree with the commission in your regulatory view on?
Judge, I think that's been asked and answered.
He's restated several times. If I may respond, I apologize.
Go ahead and
say it several times what the commission has said, but I think it'd be helpful, and I have not heard a response, what Evergy feels or thinks trackers, if they agree or disagree with that policy.
I'll allow the question, if you would just state it one more time, Ms. Mers, with maybe a little more clarity.
Sure. Would you agree, I'll try to maybe break it down into the individual justifications the commission used to see if that helps, but do you agree that with the commission when they have stated in cases that trackers violate the matching principle or tend to violate the matching principle?
Well, the company has made the case in the past that we believe that there are circumstances that trackers are appropriate, but the commission has repeatedly issued orders that state it as such as you indicated, and we take that as commission policy.
Okay, so in the future, Evergy no longer believes then that the trackers on an individual basis should be evaluated?
No, Evergy has advocated for the use of trackers in the past. And we may advocate for trackers in the future. But what we are saying is that the commission has been very clear on what it views as the appropriate use of deferral trackers, and the staff recommendations in this case is contrary to that commission policy.
Okay. So although the commission, and you know, their commission policy and case decisions aren't binding, but you're not willing to say in this case or in future cases if you would, again, Evergy would approach on an individual basis the use of a tracker in a situation.
Calls for speculation, Judge.
I'll allow it, objection overruled, but I do believe that the witness has said that they would allow in the future, or that they might ask for in the future. Do you want to re-ask that, Ms. Mers?
Well, I guess is that a fair statement? The summary the judge provided, that in the future you may.
I can't speculate what we might do in the future. I think I answered the question that is a possibility that the company would evaluate, but obviously that the company would take into account the commission policy that it's repeatedly ruled on as it relates to that.
Okay. And I know you're not a lawyer, but you are, I believe, the head regulatory affairs liaison for Evergy, is that correct?
For this docket, yes.
Okay, for this docket. Is it your understanding that Missouri law allows Evergy Missouri West to defer prudently incurred depreciation and property tax expense?
Yes.
Okay.
Under the PISA statute.
Okay.
Did you say, I'm sorry, can you repeat the question?
Yeah, I can. I believe you had answered, but that does Missouri law allow Evergy West to defer prudently incurred depreciation and Missouri property tax expense? Okay. Do you think the ability to defer depreciation and property tax expense violates the matching principle or skews rate-making results or dulls incentives to operate efficiently?
Well, I'm not an accountant, but I believe that that's authorized under Missouri statute.
Could you provide a definition of the matching principle?
I would not venture to provide an accounting definition, not being an accountant.
Okay. Would you agree that from a high level view that the matching principle is a theory that quantifying revenues, expenses, rate bases, and capital structure at the same time maintains a proper relationship between those cost components?
Generally speaking, yes.
Okay. If the commission acknowledges that the revenues, depreciation, and property tax caused by the purchase of Persimmon Creek will be captured in between rate cases through those various mechanisms, wouldn't tracking tax benefits during the same time period comply with the spirit of the matching principle?
No. What I testify is that the staff request for a PTC tracker is inconsistent with the commission policy that they've repeatedly laid out as it relates to asking for such treatment.
And you're basing that off of, or at least one of the major examples you quoted is that 2014 case, is that correct?
Well, I think I cited several different examples.
Okay. Was the PISA statute or the plant and service accounting mechanism that allows for deferral of depreciation or the recently passed property tax mechanism, were those in place in 2014?
No, they were not.
Okay. Are you aware that Ameren, Missouri is passing the complete grossed up value of its PTCs to customers?
I'm not aware with their case.
Okay. On page 24 of your testimony, or actually page 26, I apologize, you state that Evergy Missouri West customers will immediately begin receiving benefits of the zero energy cost resource flowing through the FAC prior to the asset being recovered in base rates. Is that an accurate statement? Okay.
That's correct.
Is it your understanding that Persimmon Creek will generate negative revenues at time?
I would defer to company witness Jason Humphrey to be able to speak to the analysis as it relates to the production.
Okay.
But, to my testimony, the statement is stating that if we receive approval of a CCN, the Persimmon Creek Wind Farm will pass along any revenues that it generates through the fuel clause back to benefit customers. And in discussion with the PTC tracker mechanism, the point that we're making is that any time that you put a resource into service, there's a positive and negative regulatory lag effect. And you reference the PISA statute that allows us to defer 85%. But there's also the 15% depreciation that is not able to be deferred under the PISA statute. There's the O&M costs. There's the benefit of the revenues that are flowing directly to customers in the interim prior to the Persimmon Creek going into service, and there's a 15% of the return that also can't be realized until the resource goes into service. So there's that balance of positive and regulatory lag, and
Okay.
we're not suggesting that Persimmon Creek be treated any differently than any other Evergy Missouri West generating resource that would go into service.
During the times when Persimmon Creek is generating only to gain PTCs, so in times of negative pricing, does that negative revenue go through the FAC?
The negative revenue, I would defer to Jason Humphrey to be able to speak to that.
Okay. If you would take that, if you assume that is true, would that negative revenue act as a cost and increase the amount of total fuel costs that have to be recovered from customers?
My understanding is that if my understanding is that if the resource is offered into the market, that we're not going to be generating past the value associated with the PTCs.
And I'm glad you stated that. So if you're not going to be passing towards what the PTC would cover, but if you're not passing along the PTCs to customers, doesn't then that therefore mean the negative revenue at that time would go directly to customers through the FAC?
My understanding is that we were only going to be flowing positive revenue dollars through the FAC to benefit customers until such time that the resource is in service.
So Evergy will not be flowing any negative revenues through the FAC from this particular project?
I'm not aware of any net costs flowing to customers through the FAC during this time.
Would Evergy be willing to make that assurance, put it in writing?
I defer to company witness Jason Humphrey to speak to that.
Okay, thank you. And you mentioned earlier, and I do believe, well, I think I have a little bit more before I need to go in camera, because I think some of the information might be confidential, but I don't believe that when do you guys expect to file your next rate case?
That's yet to be determined.
Yet to be determined, okay.
But certainly will be within the 4 years under the FAC rules.
Okay. I do believe I need to go in camera to discuss the next few data request responses.
Okay, and do you have additional non-in-camera questioning or?
Let's see. Yeah, I do. I can do that a little out of
Okay.
order.
Okay.
if that's easier.
If that doesn't mess up your,
I should not.
too much,
I
let's do
hope
that.
not. Let's hope I can keep track and everybody else can too. Okay. On page 6 of your survey rebuttal, I guess we're jumping back a little. You state that staff completely ignores the 130 million NPVRR, which I believe is net present value of revenue requirement, benefit to EMW customers that the IRP demonstrates the acquisition of Persimmon Creek will provide. Is that correct restatement?
Correct.
But Evergy is not guaranteeing the results of the IRP will come to fruition, correct?
No, the IRP is based on the best information available at this time.
Okay. And in fact, Evergy has stated that the imposition of any shareholder risk in this case would cause Evergy to reconsider the acquisition of Persimmon Creek. Is that correct?
Well, if the commission determines that that Persimmon Creek is needed for Evergy, Missouri West and in the public service, then it's the responsibility of customers to pay for that service.
Is there any amount of risk that Evergy would be willing to assume on behalf of shareholders if Persimmon Creek is not ultimately uneconomic, or is ultimately uneconomic when considering the cost and revenues with this case?
Well, we're not asking for the commission. Persimmon Creek is the same as any other Evergy, Missouri West generating resource. And if the commission determines that this is a resource that is needed for the service of customers and in the public interest, then it's appropriate for the customers to pay for that service and to assume the economic risk and opportunities that's associated with this resource. Persimmon Creek has the same foundational risks and opportunities as any other resource that Evergy owns and operates.
On page 10 of your survey rebuttal, you cite some findings of fact from the Commission's order in case number EA 2019-0010. Do you recall that discussion?
I do.
One of the things mentioned is that wind generation has benefits other than cost savings, including helping to diversify Missouri's energy generation mix, providing renewable energy, and providing local and state economic benefits such as property taxes, land lease payments, and jobs. Is that an accurate restatement?
Yes, that's one of them, yes.
In what state was Persimmon Creek constructed?
Oklahoma.
And will Evergy, Missouri West pay property taxes in Missouri for Persimmon Creek?
No, but Persimmon Creek will provide renewable energy and benefits to Evergy, Missouri West customers.
And will Missourians get land lease payments?
No.
And will Missouri West have any jobs created because of Persimmon Creek?
I'd defer to Jason Humphrey for that question.
Is it your understanding of that case that the commission ordered a shareholder ratepayer risk-sharing mechanism?
Well, my understanding is that case, first of all, was that the shareholder mechanism that you're referencing was related to a negotiated settlement that was offered up. So it's a very entirely different type of case. One, you're dealing with a 22-part settlement negotiation where the company was evaluating different puts and takes. And then secondly, it's just a different type of project where you've got Liberty looking at a 600 megawatt, 3 different wind farms for construction of a new CCN build compared to the operating existing asset of Persimmon Creek. And you're dealing with a tax equity finance type of program structure that's very different from Persimmon Creek, where the production tax credits will flow directly back to customers once the asset is in base rates.
So you're understanding that there are also risk-sharing mechanisms related to both Ameren and Evergy's solar projects, community solar projects?
My understanding is that there's a few voluntary program examples that are related to negotiated settlements.
And are you familiar with the Commission's decision and recent gas certificates of convenience and necessity that have ordered hold harmless provisions?
I'm not.
Okay. I have another exhibit to mark. It has confidential information, but I think I can avoid mentioning any of that on the record.
We'll still mark that as confidential.
Yes.
So the next number is 108.
I believe that would be Exhibit 108 for staff.
Yes, and we'll mark that 108C for confidential.
Yes. And again, trying to avoid the amount of in-camera we have to do. But do you recognize that presentation?
Yes,
Okay, and when is that presentation dated?
December 29th, 2022.
Okay, and does that presentation, or is that presentation a presentation on Evergy's capacity positions?
Yes.
Okay. I think the rest of it is probably confidential, so we can just end the questioning there if it's okay to admit that as an exhibit.
Would there be any objection to Exhibit 108?
We would not object it. It is all confidential, however.
Okay. Would there be any other objection to Exhibit 108, and that is 108C? No objection, then I will admit that.
That one next. Yeah. Okay, and then I would like to mark another exhibit. So I believe this would be 109, and I do not believe that this is confidential at all. So.
Nicole, is this 3 pages, or is there one missing?
I think it's, I think the third page is just the little extra part of the internet stuff, the web links, if that's
Well,
okay.
it just looks like it starts here in the middle of the sentence.
Oh, I believe it's just the way our printing
Oh, I
code put
got you.
off. I apologize for that.
Yeah, thank you.
You can have my copy.
What are you gonna use?
Yeah, it's not that long, so hopefully I'll remember what it says. Okay, so does that article contain discussions of the Persimmon Creek project?
Yes.
And I believe it's dated 2018. Is that correct?
Yes.
And it is kind of an encapsulation of the construction of the project. Is that fair?
Appears to be.
And it states in that the build cost is $270 million. Is that correct?
Can you point me to where it states that?
I think it's the headline.
Oh, I'm sorry.
No, it is okay.
Yes.
Okay. And is it your understanding that that is the original build price? Or does that comport with what Evergy has,
That is what the headline states.
and does that, when Evergy was doing its due diligence, and does that comport with what you understood the purchase price, or not purchase price, the original build price to be?
I would defer to company witness Jason Humphrey to speak to the project
Okay.
specifics.
On the specifics. is, and if you need to defer that, this one, that is fine as well, but is it your understanding that the project cost for Evergy is 245 million? 247?
245.7.
245.7, excuse me. Okay. And project was built in 2018.
Correct.
Okay. I would go ahead and offer that exhibit as well.
Can you just describe briefly where this article is from?
I believe it is from the original builders of Persimmon Creek Scout Energy.
So this is on their website?
Should be, yes.
Your Honor, I think I'm going to object. I don't think there's sufficient foundation to have it entered into the record.
Would there be any other objection to Exhibit 109?
Well, it's hearsay as well, but I think we just can't take things off the internet and say, let's enter it into the record.
Any other objections? I think I will sustain that objection. I don't think there's been a foundation laid for this document. So I'm not admitting that.
Just to clarify, Mr. Doherty, you said that you think that that might be the purchase price, but to check with witness Jason Humphrey to make sure? Just to...
Yeah, I stated that the purchase price was $245.7 million plus working capital adjustments.
Okay, and that's for Evergy?
For Evergy.
And that Mr. Humphrey would know what it costs Scout Energy to build the project to?
I defer to
Defer to
Mr.
him?
Humphrey
Okay.
for those.
Just wanted to make sure I was going to be asking the right witness the right question then. Okay. I think I am out of non-confidential questions. So I do believe that we have to go in camera for the next portion. I don't know if it's easier to see if there's bench questions or redirect and then do all of the HC. I know we've done it different ways, but it's...
We'll go in camera, and while we're in camera, we'll get cross and bench questions for those in-camera portions before we come back out. So I would ask the attorneys to make sure that the people that remain in the room are eligible to hear confidential information. And anyone who is not, to please leave at this time. ahead and go back on the public session.
And that would conclude my cross-examination. I have nothing further. Thank you for your patience.
All right. Are there any bench questions for Mr. Doherty? Mr. Chairman? Did you?
Yes. Then we're back on the record, okay. All right. Still morning. Good morning.
Good morning.
So staff has brought up that Evergy West needs, Persimmon Creek. Well, I guess staff is questioning whether or not it's needed because SPP evaluates Evergy on a combined basis. So, in your words, why is it not appropriate for us to evaluate Evergy's capacity on a combined basis similar to SPP?
Yes, if I may, Mr. Chairman, Kayla Messamore provides extensive testimony on the need and how we look at Evergy Missouri West on a separate and combined basis in the IRP process. So I'd recommend that would be a good question for her.
Okay. So the significant negative locational marginal prices, is it Evergy's understanding that Persimmon Creek and other wind farms too, that you can still generate at negative prices because of the tax credits? But are you not displacing higher cost generation at the same time that the wind farm is operating?
That's my understanding, and Kayla Messamore could speak directly to that. But I would say that, the wholesale revenues is only one component of the factors that Kayla's team looks at in evaluating in the IRP. There's multiple factors that are involved in addition to the wholesale revenues.
All right, I'll save the rest for Kayla. I think I have one more that you can answer. All right, so staff has stated that Evergy is manipulating the inputs of the IRP process to get the result that you want of this wind farm. What are your thoughts? And is it ever appropriate for a utility to select the inputs for IRPs?
Well, I would say that the process that we went through, and again, Kayla Messamore provides extensive testimony on this, as well as the methodology that we used in the most recent IRPs. And she can provide feedback on the staff allegations specifically there. But we go through the IRP that takes into account multiple factors. And when we came through the last annual update, it showed that wind was the most advantageous resource for Evergy Missouri West customers relative to other alternative options. Then when we went to implement the plan, and Jason Humphrey can speak to the RFP process that we went through, which was a competitive RFP process, that different companies responded to, and then went through an evaluation of that RFP process and ultimately selected Persimmon Creek as the best available resource to serve those needs. Then Kayla took Persimmon Creek and included that back into the IRP process, and what it found was it produced even greater benefits for Evergy Missouri customers than just generic wind when it did it before. So the 130 million net present revenue revenue requirement benefits is increased over the generic wind, which was around 64 million when they did the original modeling.
Okay, so staff has suggested that the net present value of the revenue requirement is not like the best way to measure the low-cost option for meeting customer needs, because it doesn't take into, I guess, what is their argument? It doesn't take into consideration the constraints of renewable resources, I guess. So, not talking about Persimmon Creek, do you believe the Commission's IRP rule needs to be amended to address this concern, or do you think it is not a concern?
Yeah, I would say that our process in working through the IRP is consistent with how we've done it for many years and how other utilities perform the IRP. It's an extensive stakeholder process where parties are involved. And the staff suggestion that, their condition be applied to a single utility for future CCM proceedings is kind of inappropriate rulemaking in the context of this docket. But I would defer to Kayla Messamore to kind of expand on the IRP process and the different aspects of the modeling that we undertake.
All right, I think I have one more that you might be able to answer. So we heard staff talking about building combined cycle gas to meet your energy and your capacity needs. So knowing that SPP's increasing their reserve margins and there's more volatile market prices, so why isn't Evergy West building a combined combustion turbine other than dispatchable resources?
Yeah.
Other than dispatchable or other dispatchable resources.
I believe that Kayla Messamore can speak to the fact that we do have dispatchable generation in the future as part of our IRP plans. And, the IRP is a constant, continual process of updating the modeling based on new known factors. And so she can speak to what we are seeing in terms of capacity needs in the future.
Sounds like Kayla's going to have a very busy day on the stand.
Well, she is our expert witness
Oh, there
that
you
speaks to the IRP modeling.
Excellent. That's all I had, Judge. Thank you.
Thank you. Are there any other commissioner questions? All right. I don't have any questions. Is there further questioning based on the commissioner's questions from Renew?
No, thank you.
Public counsel?
Sorry, I'm really short. No questions.
Staff?
No, thank you.
Is there redirect?
Yes, Judge, briefly. Mr. Dory, I'd like to go back to the chairman's discussion with you, and where you were talking about the IRP process that produced generic wind as being the most advantageous resource available. Do you recall those questions?
Yes.
I just want to make sure the record is clear. You were saying they ran the IRP and that's what it produced. Wind was the best thing we could do for the consumers at that point in time, correct?
Correct.
And then did you suggest that Mr. Humphreys did an IRP and found out there really was a wind project out there and it was called Persimmon Creek?
He did an RFP, yes.
Okay, and based on that RFP, what did it show?
It showed that of all of the respondents to the RFP, Persimmon Creek provided the best value for Evergy Missouri West customers.
And then did you suggest to the chairman that at that point they reran the IRP with a real wind resource in it and it produced greater net consumer benefits?
Correct.
And that's where the $130 million of net present value revenue requirements number comes from, is that right?
That's correct.
So from your perspective, is that manipulating any inputs?
No.
I'd also like to go back to your discussion with staff counsel about the Liberty case. I think on page 10 of your sir rebuttal, you talk about that.
Yes.
Would you look at lines 24 and 25 where the commission states what the public policy of this state is in that case?
Sorry. Okay.
What is the public policy according to the commission?
It is the public policy of the state to diversify the energy supply through the support of renewable and alternate energy resources. The commission has also previously expressed its general support for renewable energy generation because it provides benefits to the public.
Okay, then on lines 12 and 13, or through 15, what's that indicate about wind generation?
Wind generation has benefits other than cost savings, including helping to diversify Missouri's energy generation mix, providing renewable energy, and providing local and state economic benefits.
Okay, then it goes on, and we can all read that. From your perspective, is Evergy's position in this case consistent with that public policy?
Yes.
Do you believe that's the same, that would be the same answer if I ask you whether the staff and public counsel's position is consistent with that public policy in this case?
No.
Okay. I'd like to go to, what's this one? I'd like to go to the transcript that you were asked about in the securitization case. I think that's 109. Well, I'm sorry, 107. Do you have that? And I'd refer you to page 258 of that transcript.
Okay.
There about starting with a line 2, turning back to your sir rebuttal testimony, et cetera, you were asked a question about how you would respond to Ms. Mannell's conclusion that much of the extraordinary costs Evergy, Missouri West incurred because of Storm Uri were the consequence of imprudent resource planning. Do you see that?
Yes.
Do you recall that Ms. Mantle was expressing a view about how much capacity Missouri West needed in that case?
That's my recollection.
Can you explain what you recall about her position regarding the need for additional capacity for Evergy, Missouri West in that case?
That Evergy, Missouri West's lack of owned capacity left it vulnerable to the wholesale market.
And did the commission look at her allegations regarding imprudent resource planning in that case, that securitization case, to your knowledge?
I believe so.
And did they reject her position that the company had imprudent resource planning?
Yes.
I believe there was a bench question regarding whether there's a need on a combined basis for additional capacity. Do you recall that? And I believe you did refer that to Ms. Messmore.
Yes.
But just in the event that she doesn't get to answer questions, I'd like to ask you, is it your understanding that there is or is not a need for capacity on a combined basis in this case?
I believe that there is a need for capacity.
And she can explain how much and when we need it?
That's correct.
Okay. Then there were some questions regarding negative locational marginal prices in generation at that point. Let me withdraw that. There were questions to you regarding wholesale revenues being factored into our analysis. And I'd like to ask you, what is your understanding of how other plants besides Persimmon Creek how they would be evaluated if you were just comparing the SPP revenues versus the embedded revenue requirement costs that are out there for those specific plants.
Well, my understanding is that in most cases, all of our other generating resources would not meet the same test and standard that staff puts forth.
So other coal plants or nuclear plants, they wouldn't meet that standard either. Is that what you're testifying to?
That's correct, and that's what Kayla Messamore testifies to.
Okay, she can expand on that, I'm sure.
Yes.
Okay. Oh, you asked some questions about the benefits to consumers of, I think, in the context of the production tax credit. Do you recall that?
Yes.
I'd like for you to expand on what you see the benefits of Persimmon Creek to consumers are.
I believe Persimmon Creek is in the public interest because we identify that there is a need for energy and capacity to serve Evergy Missouri West customers, that the IRP shows that it's projected to reduce costs to Evergy Missouri West customers relative to all other alternate options, that it's going to produce renewable energy certificates that will benefit Evergy Missouri West customers. It's going to produce production tax credits that will benefit directly Evergy Missouri West customers when the resource goes into base rates. As an existing resource, Persimmon Creek has a history of strong operational performance in the SPP market that it's demonstrated over the last 4 years. As an operating resource, it's not subject to some of the same construction and supply chain risks that we are seeing in the industry currently. It is going to add a renewable energy resource to Evergy Missouri West generation portfolio, which currently has no owned wind, and it's consistent with Missouri energy policy.
Okay, you were asked some questions about the revenues that would be flowing through the fuel adjustment clause. Do you recall those?
Yes.
Is it your understanding that revenues from SPP that Persimmon Creek would generate would flow immediately through the fuel adjustment clause?
That's my understanding, yes.
Would that be a benefit to consumers?
Absolutely.
And that would be before that plan is actually put in a rate base and shareholders are getting a return on that plan. Is that true?
That's true.
And they'd also be getting energy from it before it's put into rate base. Is that right?
Correct.
You asked some questions about the PISA statute and how it allows for the deferral of depreciation. Do you recall those?
Yes.
Does the PISA statute, in your mind, express public policy toward renewable energy in our state?
It does. The PISA statute states that the utility must spend at least 25% of its annual capital budget on grid modernization, and renewable energy is specifically called out as an example of grid modernization.
Is there other legislation or statutes that would also suggest that the public policy of this state it favors renewable energy?
There's also the renewable energy standard in Missouri, and it was referenced earlier, the securitization statute that recently passed in Missouri for the energy transition allows for the use of the securitization proceeds to be used to reinvest in renewable energy.
And I believe you were asked some questions about the rate case where KCPL and KCPL Greater Missouri Operation were requesting trackers and they were rejected by the commission. Do you recall those?
Yes.
Would you explain your understanding of what the commission's policy is regarding trackers generally?
My understanding is that the commission has previously held that trackers need to be extraordinary events that they need to be significant in cost and not tied to regular occurrences. And I don't think that the PTC meets any of those requirements. The PTC has been around and available for many years and used.
Is it volatile?
No.
And when you were discussing that case, that was about a deferral, not just tracking it, not keeping track of the costs and the revenues. Is that right?
That's correct.
Is the company willing to keep track of the costs and revenues associated with Persimmon Creek, just like they would any other power plant in this case?
That's correct.
And that's different from deferring a cost.
That's correct.
Okay. Judge, I think that's all the questions I have. Thank you.
Thank you. Thank you, Mr. Doherty. You may step down.
Thank you.
I've had a request from the commission to do our lunch break a little bit later, like from 12:30 to, say, 1:45. So we're going to try to do that unless there's some witness conflict with that. So let's go ahead then with the next witness.
Thank you. Call Jason Humphrey.
Would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
Yes, I do.
Thank you.
Thank you.
If you could spell your name for the court reporter.
Yeah, Jason, Jason, Humphrey, Humprey.
Go ahead.
Mr. Humphrey, having stated and spelled your name, by whom are you employed?
I'm employed by Evergy, Missouri West.
What is your position there?
My position is the Vice President of Development and Assistant Treasurer.
Is your job title different today than when you submitted pre-filed testimony in this case?
Yes, it is.
And how is it different?
I was promoted in the role that I'm in to Vice President, so that's the difference.
Did you prepare direct, supplemental direct, and surrebuttal testimony in this case on behalf of Evergy, Missouri West, which have been marked as Exhibits 2, 2C as in confidential, 5, 5C as in confidential, 8, and 8C as in confidential?
Yes, I am.
Did you also submit an errata to your surrebuttal testimony in this case, which has been marked as Exhibit 11?
I did.
Other than the errata and your change of job title, do you have any corrections to your direct, supplemental direct, or surrebuttal testimony?
None to my knowledge.
If I were to ask you the same questions in those testimonies, would your answers be as set forth in Exhibits 2, 2C, 5, 5C, 8, and 8C?
Yes, they would.
And are those answers true and correct to the best of your knowledge and belief today?
They are.
At this time, Judge, I would move to admit Exhibits 2, 2C, 5, 5C, 8, 8C, and 11, and then tender the witness for cross-examination.
And would there be any objection to those exhibits? Seeing none, I will admit Exhibit 2 and 2C, 5, 5C, 8, 8C, and 11. All right, is there any cross-examination from Renew?
Yes, thank you. Good morning, Mr. Humphrey.
Good morning.
Mr. Doherty was asked, I believe, by Mr. Fisher about statutes that encourage renewable energy investments. Were you here for that?
I was.
And that included PISA, the Renewable Energy Standard, and the securitization statute. How do you believe that Persimmon Creek would meet the objectives of these statutes and regulations?
Yeah, PISA in particular encourages renewable energy investment for generation, renewables exclusively, in fact. In order to qualify for a PISA deferral for a generating asset, it must be renewable, in this case, like Persimmon Creek. The other standards also encourage the investment for the state of Missouri in renewable energy, but we do not anticipate using this for res compliance here. So PISA is the most directly applicable statute for Persimmon Creek.
Thank you. And I believe in your testimony and in Ms. Whipple's opening statement, you all discussed, the rapidly changing market conditions, inflation, supply chain issues. Based on your knowledge of current market conditions, do you still feel that Persimmon Creek is the best resource to meet the company needs and the needs of its customers?
Yeah, absolutely, I do, and probably enhanced so. Inflation continues to be well above the Fed's 2% target, and the other publicly available market comparisons we have for recently executed deals are a full $1,000 a kilowatt, or 45% more expensive than the Persimmon Creek asset. This was a hard-fought negotiation that I lived and firmly still believe this is the best investment for Missouri West customers today.
All right, I believe that's all the questions I have. Thank you.
Thank you. Public counsel?
Nope, no questions. Thanks.
Staff?
Hello, and congratulations on the promotion.
Thank you, Nicole.
On page 11 of your rebuttal, you discuss the possibility of additional investments that might be necessary due to changes in wildlife conservation status. Do you recall that?
Let me get to the page.
Take your time.
Set 11?
Yes. 11 of rebuttal.
I'm there, and yes, I recall the question.
Okay. The LCOE analysis in this case doesn't include those additional capital expenditures that might be required for wildlife fertility mitigation. Is that correct?
Could you repeat the question? I
Sure.
think I understood, but.
Sure. Does the least cost of energy analysis in this case, it does not include any additional capital expenditures that might be required for wildlife fatality, Jesus, mitigation, correct?
Thank you for repeating the question. I actually did misunderstand. So LCOE is levelized cost of energy. So it takes a look at, over the lifetime of a project, how much each megawatt hour costs to produce, kind of on a revenue requirements type model. Because Persimmon Creek is fully compliant with all laws and regulations today, there is no incremental capital cost included in that levelized cost of energy analysis, because today the plant is fully compliant with all rules and regulations.
In your experience, what kind of investments would be necessary or could be necessary to mitigate wildlife death?
Generally, it's, from my understanding, a condition on the operation permit of the plant. Typically, you might limit the plant to operating only between, midnight and 10 p.m. because that 10 p.m. to midnight window would be the most impactful to the habitat. But importantly, there is no such restriction under Persimmon Creek today, and it is fully compliant and has been since the day it went into operation.
And would you know if there had to be permit limitations on operations, what the cost of that could be?
I would not care to speculate, no.
Okay. I'm trying to watch the HC information, so if I go too far, please let me know. And we can move to in-camera, but it's my understanding that the species is a species of concern, but not endangered in the area.
Correct.
Is that correct?
Yep.
If it would become endangered, would that require Evergy to curtail production to mitigate bat deaths?
That's completely unknown. It's certainly possible, just like it would be possible at a fossil generating plant today. If air permit requirements were changing, the operation of that plant may change in time. The fact of the matter is today that Persimmon Creek has no restrictions on the operation, and there's no pleading to add those restrictions.
Are you familiar with wind farm operations in the state of Missouri in general, maybe some of the other utilities?
Yes, I am generally familiar with wind farm operations.
And is it your understanding that some of those wind farms have experienced increased curtailment than what was originally proposed due to required wildlife mitigation?
I'm not familiar with other plants' wildlife mitigation strategies, no.
Okay. So you wouldn't know if it's unlikely, based on experiences that have been seen in Missouri, for wildlife mitigation to be imposed or increased after the fact?
I won't speculate on others' assets. I will say this plant has been in full SPP operation for 4 years with none of those requirements, which is a pretty substantial amount of time. It's not an immaterial amount of operation. Full 4 years in SPP service without these restrictions.
Do you think that knowledge of what other utilities have experienced with curtailment issues, especially if Evergy claims that one of the reasons it needs this plant is to get that knowledge and operations, that should have been a due diligence or at least looked into?
We certainly looked at the environmental profile of the plant through due diligence that's extensively covered in my testimony, in fact, on page 11, that you've pointed us to. And it's not speculative. We don't have to speculate on what others have done. We have the firm operational history of Persimmon Creek to point to in this case.
Do you know what times, most likely times of the year and times of the day, are ordered for mitigation of bat deaths?
I do not.
Okay. Assuming Evergy West is granted the CCN in this application, is it Evergy's position that ratepayers are solely responsible for future revenue losses that may occur to known risk at the time of resource selection?
I think it's the obligation of Evergy as the utility required to serve to be compliant with rules and regulations at that time. And so as rules and regulations change, we update our investments to comply with those rules and regulations. No different if there was guarding that must be put on the line or air retrofits in an existing plant. This is no different than that situation.
So Evergy wouldn't be willing to share in risk of future revenue losses?
I think it's Evergy's obligation to be compliant and for those prudent investments to be made at the time that they're required.
So I was deferred a few questions to ask of you. So do you know what the expected annual operation and maintenance expense of Persimmon Creek is?
Yeah, I think it's about $8.1 million. It'd be part of my schedules to my direct testimony.
Okay. And then I think we will have to go in camera again.
Yeah, depending on where we venture from here, I was going to suggest that.
All right. Let's go ahead then and go in camera.
And then
All right, Ms. Mers had completed her cross-examination, I believe. So we will see, are there additional questions by the commission? Mr. Chairman, did you have? Okay. Commissioner Holzman.
Thank you. My new responsibility is on the MISO side of the RTO. I've kind of been looking at some of the wind farms that have negative cost pricing, and a lot of it has to do with the congestion that's surrounding the lack of the ability to move the power to where it can be used. Talk to me a little bit about the congestion around this project and what kind of transmission you have available to get that power so that it can be sold at a profit.
Great question, Commissioner. I'll point, if you want to do some further looking, to my confidential schedule, JH11. We actually evaluated the transmission path from Persimmon Creek to Missouri West, and in fact have applied for firm transmission service with the SPP for the asset. But what we found was, of the wind projects we evaluated in the RFP, this plant had the best transmission path from the kind of wind belt out in western Kansas and Oklahoma back to Missouri West. And that transmission path was improved in 2026 when some of the FERC Order 1000 projects come into service. And so we really did value the ability to get that energy back to Missouri West, and we found that this site was the best from a transmission perspective in doing that. Generally, negative prices, though, are a congestion or a reliability curtailment within the marketplace to not overload any particular node. And so that building of east to west and north to south transmission that'll happen over the next 20 years will dramatically transform the amount of negative pricing that any of these resources see.
How far out do you envision storage being a part of, we heard staff say that generation at night causes some negative pricing. How far out are we, years from being able to take an asset like this and pair it with reasonable utility-grade storage to where it can firm up its transmission?
I honestly think the time is now, Commissioner, for that. One of the important aspects of us owning this plant, rather than it being a PPA, is all the infrastructure associated with that plant comes in it. And that includes the transmission system interconnect. And so what we could do, day one, if it made sense for our customers, is site a battery behind the interconnection meter for that plant and take that notional 10% accredited capacity and make it 90-95% from SPP rules today with that battery. The technology is there. You can see other parts of the country have pretty significant build out of batteries. I think the SPP will be a very fast follower on that, given the amount of negative prices it might see, but also just the huge renewable potential that that part of the country has.
Is there any capacity inside is there any capacity inside the $245 million you're asking for to spend on something like that, something like storage to help create value added?
There's not as part of the asset acquisition.
Value added asset.
There's not as part of that initial acquisition, but it does buy us that optionality to be able to consider that in the future. It's important to note that Missouri West owns no wind today, and really very few renewable resources. And so this would be the first major acquisition that would give Missouri West that option in the future to consider. The 10% accredited capacity that we've estimated is a very conservative approach. That assumes we get no firm transmission service, and the SPP just kind of takes its default lowest level number of accredited capacity. If firm transmission makes economic sense, we would fully anticipate that asset to be accredited at some higher number than 10%.
How high do you think it could go?
Witness Messamore would probably have a better idea on our peak wind, but I think 20 to 25% is kind of typical on assets that we have accredited capacity at.
Do you know of any assets in the SPP footprint now that are accredited that high for their capacity?
I believe so, yes, and Kayla could speak specifically to those.
Okay. Thank you. Thank you, Judge.
Thank you.
Judge?
Mr. Chairman, did you?
Yeah,
Oh, I'm sorry, Mr. Commissioner Kolkmeyer.
Okay, sorry, Commissioner. The judge reminded me of a question I had asked earlier that was deferred to either Kayla or yourself. I had asked, I think, your attorney in their opening, what was the cost to recertify as far as I don't know if it's appropriate for you or Kayla, but if you can answer, if not, then if not, punt it.
I can tell you generally to have an engineer come out, the original equipment manufacturer, do like a full recommissioning of the site, it's about $100,000.
Okay. And just to follow up on Commissioner Holzman's question, so if you were to put, or want to put battery storage, assuming this is approved and you wanted to, you'd have to come to the commission for approval to put that in and to put it into rates and everything.
That's correct.
Okay. Just the same as if there was an unforeseen cost on wildlife or something else, you would have to come to the commission and ask for compensation for that as well.
That's correct. It would be subject to a prudency review.
Thank you.
Any other commission questions?
I have one more follow-up. And I don't know if this is an in-camera question or not, and I probably have it here, but I'm curious. If you were to build this today from scratch, what do you think it would cost to do?
I think the best public data point I have would be the AEP announcements that are in my testimony. They've signed a number of build transfer agreements to construct new renewables at a cost that is north of $2,200 a kW, rather than about $1,250 for this asset. So at least 40% higher.
40% higher. Okay, thank you.
All right, I still have a few more for you. And like I say, bear with me if I ask you the same thing I asked you earlier. If I ask you something that is confidential, please let me know. So first, can you just explain the difference between capacity factor and net capacity factor?
Yes, and I'll add a third to that, which is just capacity. So capacity is the ability of a site to generate. If you think of the old United Way thermometer that you might have in a hallway for your fundraising campaign, the capacity of that site would be the full value of that thermometer. So for ease of math, let's just call that 100. The capacity factor, or net capacity factor, net's a little bit better to use, is the amount of time that thermometer is filled up to a certain level. So in the case of Persimmon Creek, which has a historical net capacity factor of about 50%, if you took all 8,760 hours that are within a year, Persimmon Creek generates about 50% of its full nameplate around the clock. Okay? Capacity factor without the net basically says that you're selling all energy produced, when in reality you use some of that for internal services at the plant, keeping the heaters on, keeping the guy's office computer running, those kind of things. So net capacity factor is really what the grid sees, and we can think of that as the percentage of full capability to what it actually produces.
Okay. So for the purpose of assessing the true output of a generation resource, you would say it's best to use net capacity factor.
For energy, that is correct.
In your testimony, you referred to capacity factors. Mr. Lubert, in his testimony, refers to capacity factors. But in Ms. Mazamore's supplemental direct, she refers to net capacity factors for wind.
They are generally interchangeable, and certainly in my testimony, I'm referring to net capacity factor.
So basically, those are meant to be apples to apples in this situation. Okay. During the design phase for Persimmon Creek, do you know what the various P50, P75 capacity factors were?
Through a technical engineering report we had obtained during diligence, I have a sense for what the estimated capacity factors were during construction, yes.
And can you share those, or is that confidential?
I cannot.
Okay, that, you have that, but that is,
Yes,
we'd have to go in
correct.
camera for those. Okay. We will come back to that.
I have a follow-up if you want me to ask.
Go ahead while I see what I've already asked him.
If you were going to build this, you know, from raw land, how long do you think it would take to get to the point where you're operating at this capacity?
Yeah, if we were starting from whole cloth, self-developing a project, going and securing real estate rights, I'd say 5 to 6 years would be an optimistic scenario. In order to enter an interconnection application now with the SPP, you must have 100% land control for both the site itself and the path to interconnect, and that's before you can submit the application. Right now, the SPP generator interconnection queue is about a 5-year process to get through all of the studies and finally interconnect into the grid.
This question, you may not have the answer to, but I'm curious. It's in operation today as we speak,
Yes.
right? Do you have any idea how much power would be making it to Evergy, Metro West? I know it's in an RTO, so you can't track those ions, but do you think that percentage of what's being consumed by Evergy, Metro West would go up under your operation of it? Or would it not, does it not matter once it's in the RTO?
Yeah, our bid strategy to the RTO may differ a little bit. I'll make the important point, though, that as soon as we close on the deal, Missouri West customers will begin to benefit right away from the operation of Persimmon Creek. Those revenues that are generated in the SPP marketplace will begin flowing to those customers through the fuel adjustment clause from day one. So there's not any lag between us closing on the deal and Missouri West customers getting the benefit of that green energy through the ownership of Persimmon Creek.
Who's predominantly getting the benefit right now?
The owners of the plant, which is Scout Clean Energy and Elawan.
Okay, thank you.
Thank you.
Elawan, Elawan, I believe.
I'm going to kind of repeat myself here from what we talked about in camera, but again, don't say anything that should be confidential. So we talked about post-construction fatality monitoring, wildlife fatality monitoring, and I asked you, but I'm just going to ask you again, did any additional wildlife monitoring occur after November 2019?
None that I am aware of.
And why is it that Evergy did not do any, or not Evergy, but do you know why the current owners and why Evergy didn't believe that further monitoring is necessary?
Yeah, the monitoring that had been conducted was concluded in 2019 with no action. The plant is in environmental compliance today fully and continues to operate that way. And so that was what we diligenced, and that's the conclusion we reached.
And you said that you were aware that the results of monitoring that had been done were shared with the Oklahoma Department of Wildlife and Conservation. And can you just repeat kind of what you told me then about that? I don't believe that should be confidential.
The plant had entered into a voluntary bat and bird protection plan as part of the construction of the site. And in fact, that was taken into consideration when the site was actually decided where it would be located was to minimize bat and bird impacts. And so as part of that voluntary compliance plan, they conducted the bat and bird study.
And do you know what the response from the Oklahoma Department of Wildlife and Conservation has been?
No action was taken.
And is the net capacity factor for Persimmon Creek, that's not a confidential term, is it, or is it?
I think the precise point estimate might be in my direct, but
Okay.
it's generally about 50%.
And then I asked you, and I think you said you'd be able to describe in the public session, Schedule JH7 to your supplemental direct testimony discusses the levelized cost of energy. Can you explain how that number is determined?
Yeah, levelized cost of energy is generally a kind of bottoms-up build-up of the revenue requirements for an asset, and then it is divided by the production from that asset to come with a kind of around-the-clock dollars per megawatt hour view of the potential cost of that asset. It is generally a comparative metric, but it takes into account things like anticipated taxes, anticipated O&M, the cost of the asset itself. The construction cost is certainly the biggest input to that analysis. And then out of the number of megawatt hours produced, you can come out with a single number that allows comparison between alternatives. I think the Commission has historically recognized LCOE as the best comparative metric between generation options because it allows for that like-for-like comparison, that really strong apples-for-apples comparison of building up the revenue requirements over the anticipated generation and coming out with that firm dollars per megawatt hour metric.
And then back to our wildlife monitoring. On page 9 of your SIR rebuttal, there was a statement about the post-commercial operation facility monitoring study conducted in 2018 to 2019 had higher rates of bat mortality, but no additional action was taken by the Oklahoma, and hasn't been since then. Do you know when, and again, I apologize, I know we talked about this before, but when those, when the Oklahoma Department of Wildlife was informed of those results?
I think it was contemporaneously to the study as part of their voluntary bat and bird plan.
Okay. And do you know if there was any kind of official response from Oklahoma?
I cannot recall sitting here today.
Okay. And then back to pricing. Does Evergy West sell power back into the SPP at a negative price?
Yes.
And can you explain why you would do that and under what conditions or scenarios?
Yeah, we think about kind of a break-even analysis when we would do that. Every megawatt hour of energy produced from a renewable resource that qualifies for a production tax credit has an associated benefit with that. In this case, $26 per megawatt hour for a production tax credit. So you and I would be fine selling at negative $26 to get back to zero. Same thing with RECs. RECs today, I think, are trading between $3 and $3.50 per REC. And so you could take that $26 and add to it a negative $3.50 that you would get from selling the renewable energy credit, and now you could bid the plan into the marketplace at a negative $29 value. So that is why we would be willing to generate in negative market conditions, because we reach that kind of point of indifference where it's you're back to zero bubble.
Okay, and then I think council asked you this, but just in case. If Evergy West sells energy into SPP at negative prices, do those costs flow back through the FAC, the fuel adjustment clause?
It is my understanding that they do, yes.
Okay, and can you explain how that happens?
Yeah, it's, I think net market revenues and net market purchases are what flow through the FAC, and so that includes those negative hours of pricing.
Okay, thank you. That's all the questions I had, and I don't believe any of the other commissioners have more. All right. Okay, as much as I, don't want to give you all time to think up more and more questions. It is almost 12:30, and I said we would go ahead and break for lunch, and we're probably past due for a break anyway. So I think we'll break here for lunch and return at 1:45. And we will continue with the further cross-examination based on commission questions of Mr. Humphrey. So we can go ahead and go off the record. Thank you. ahead then and go back on the record. Okay, we are back on the record after our lunch break, and Mr. Humphrey has returned to the stand. And I wanted to see, Mr. Humphrey, I may still have another question for you before we start the recross.
Judge, this is Commissioner Holzman, just letting you know I've joined online.
Thank you, Commissioner. If you have questions, we may need you to speak up just a little more, but we could hear you, but.
Thank you.
Okay. I don't see any additional questions right at the moment, so I'm going to go ahead then and let's go to further cross-examination based on commission questions. Anything from Renew? Public counsel?
That's a negative, ghostwriter. No, sorry.
Staff?
I do. And unfortunately, I do think I misspoke, and there might be one that will have to be in camera again, but I will save that one for last. Okay. You were asked some questions by the bench about post-construction monitoring and wildlife mitigations. Do you recall those conversations? Is Evergy moving towards renewables due to potential tighter regulations on fossil fuel generation, such as carbon capture?
No, I wouldn't characterize it that way. The IRP takes into account a number of different features to produce a plan that serves many different potential outcomes.
And you were asked some questions by Commissioner Holzman about battery storage. Do you recall that?
I do.
Is battery storage in the IRP today?
I don't believe so, no.
Okay. And so there's no current application pending with this case or separately for battery storage?
Yeah, that's correct, but that's optionality that the company retains only when it owns the asset and the interconnection to the larger SPP high voltage transmission grid.
Okay, and do you recall being asked a few questions about the cost to build the project?
I do, yes.
Is it your understanding, or can I ask, do you know the original build price or cost for Persimmon Creek?
I believe I do, yes.
Okay, and is that number confidential, or can you state it on the record?
I believe I can state it on the record.
Okay.
It's shown in a press release to be about $270 million.
Okay. And you also mentioned talking about timelines for projects such as these and the ability to, why Evergy finds this project more perhaps advantageous. You stated that SPP had requirements like 100% land control and that there is a queue that projects have to get through. Yeah. So your understanding, however, though, that there are projects already in the queue that would have 100% land control and be closer to completion that are optioned out for utilities to purchase?
Yeah, we were offered a number of projects in this RFP, and on every metric evaluated, in fact, Persimmon Creek was the best and most appropriate choice from Missouri West.
But you could get, if needed, it wouldn't necessarily always be 5 to 6 years for a project if this one fell through.
Well,
For a project, 5 to 6 years for a project.
Yeah, I qualified my answer to the commissioner if we were starting from whole cloth, like had to start at the very beginning of a project, what that timeline would be. Certainly, there are other projects that could be acquired, and we evaluated such other projects through a competitive request for proposal process in this case, and it was found that Persimmon Creek was the best option out of those realistic options achieved.
And when did you issue that RFP?
October of 2021.
And when did that RFP have a in-service date requested?
Prior to 2025, I believe, for preferred dates.
Okay. And you had some questions about, again, the monitoring for wildlife. This project was built in 2018, correct?
It went commercial in 2018, that is correct.
Commercial in 2018. And there was monitoring done through 2019? Is
That's
that
correct.
a correct restatement? But no monitoring after 2019?
None that I'm aware of.
So only a year of data?
That's correct.
Okay. And I believe that we will have to go in camera for this, but I guess I think I can set it up outside of camera. But do you recall you had answered some questions about, I think from Commissioner Holzman, about congestion issues and transmission risk. Do you recall that line of questioning?
I do.
Okay. And do you recall that you responded that Evergy had requested or has firm transmission service?
I definitely did not say that. What I said is we have submitted with the SPP for the aggregate study to study firm transmission service for Persimmon Creek.
Okay. And if I could mark an exhibit and approach, I think this is 113 for staff. And that is 113. Is this also confidential? Yes, it will be, and then extra copies. And every time I get your badge, I'm so sorry.
Thank you.
And is this a data request response in this case that you prepared?
Yes, it is.
And can you read the first line of Evergy's response? Only if it's not confidential. Oh, we need to go in camera. I apologize. I thought we had already done that.
All right, if
Yes.
we can go in camera now.
Yes,
if
yes, yes.
That's a Oh, well, hold on, just one moment. Sorry. Okay. Did you intend to offer that Exhibit 113C?
We can go ahead if there's no objections to it.
It's your exhibit, so I just,
Yeah, we'll go ahead and offer it.
would there be any objection to Exhibit 113C?
No objection.
Okay, I will admit Exhibit 113C, which is a data request in this case, and response question number 0006. And that is admitted. And that is also confidential, I think I said. All right. Is there redirect from Evergy?
Yes, briefly, thank you. Mr. Humphrey, I think prior to the lunch break, there was a discussion with the bench and also with Ms. Mers about a roughly 15 million figure of PISA deferred costs. Do you recall that?
I do.
And is it your understanding of those costs that under PISA, do those costs ever flow back to customers?
The costs that are deferred under PISA are eventually recovered from customers, I believe, over a 20-year deferral period.
And that's under PISA?
That's correct.
Do you recall multiple conversations at this point about the RFP process and your LCOE analysis?
I do.
In either of those analyses, in the RFP process or the LCOE analysis that you conducted, did the company stilt either the RFP or the LCOE in any way to result in the selection of Persimmon Creek?
Absolutely not. My supplemental direct testimony goes into this pretty comprehensively, but this was an arm-length RFP process where we solicited offers of new generation from a number of different potential providers in the Southwest Power Pool. We had in fact shortlisted a number of projects out of that to enter into detailed negotiations with. Throughout that negotiation process, we experienced the inflation that we've seen in renewable resources in the broad market generally, and we actually stopped negotiating a couple deals because we no longer felt that they were a good option for customers. But in the case of Persimmon Creek, the negotiations fruited an asset that's less than $1,250 a kilowatt on nameplate capacity basis, with the best LCOE that we had of anything offered. And so as I opened my questions this morning, I still say after living this RFP process, that is definitely the best result for Missouri West customers.
How did the company ensure that the RFP was arm's length and objective?
Yeah, we entertained as many different options for the benefit of Missouri West customers as we could. This was sites where development was very, very early, potentially just some land leases in an interconnection queue position, in some cases not even an interconnection queue position, through fully developed resources that were de-risked from a construction and a supply chain perspective, such as Persimmon Creek. And those negotiations only occurred after a shortlisting process, and they occurred across the table as any competitive negotiation would be. There was no favoritism to a particular project or to a particular outcome. We negotiated the best deal we could throughout.
Did the company approach the RFP process in a solution looking for a problem manner?
Absolutely not.
Did you evaluate resources or consider offers for sale that were accredited at less than 10%?
We did not, but it's important to note, we've talked a lot about the capacity accreditation for Persimmon Creek here today. That is the SPP rule under the ELCC guidelines for all wind-generating resources. So that 10% capacity accreditation was the assumption that we would have made for any of the alternatives considered.
Do you recall conversations with the commission, and I think with Ms. Mers as well, about negative pricing or negative LMP?
Yes, I do.
Does negative pricing or negative LMP occur only with wind or other types of renewable resources?
No, it does not. In fact, I would offer that probably all of our generators see negative LMP prices at their particular node. It is a market signal that is trying to drive a behavior, and that behavior takes place for a number of different reasons. But there's a lot of different reasons that are not just PTCs as to why a resource would continue to operate at negative prices. Reliability could be one of those. The fact that they don't have enough time to turn off and turn back on to when they would be needed again. And so negative pricing is something that's seen at our generator nodes and also at our load nodes.
Sitting here today, do you still consider Persimmon Creek and the acquisition of that project to be in the best interests of EMW's customers?
Yes, I do.
No further questions. Thank you.
Thank you. All right, then I believe, Mr. Humphrey, that concludes your testimony. Thank you.
Thank you, Judge.
You may call your next witness, Evergy.
Thank you, Judge. Evergy calls Kayla Messamore to the stand.
Would you please raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. If you could spell your name for the court reporter, please.
Sure. Kayla Messamore, so Kayla-Messamore.
Thank you. Go ahead, Mr. Zobrist.
Okay, thank you, Judge. You've already stated your name, so please tell us where you work.
I work at Evergy.
And what is your position at Evergy?
I'm the Vice President of Strategy and Long-Term Planning.
And in this case, did you prepare 3 pieces of testimony? And I'll go through them. The first is direct testimony, which has been pre-marked as Exhibit 3. Is that correct?
Yes.
And did you prepare public and confidential supplemental direct testimony, Exhibits 6 and 6C?
I did.
And did you prepare public and confidential surrebuttal testimony, which has been pre-marked as Exhibit 9 and 9C?
Yes.
And did you also prepare an errata sheet to your surrebuttal testimony, which has been pre-marked Exhibit 10?
Yes.
And are there any further corrections excluding the errata sheet to either your direct, your supplemental direct, or your surrebuttal testimony?
No.
And if I were to ask you those questions, would your answers be as set forth in those exhibits?
Yes.
And are they true and correct to the best of your knowledge?
Yes.
And were they given under oath?
Yes.
Your Honor, at this time, I offer into evidence direct testimony Exhibit 3, supplemental direct testimony, both public and confidential Exhibits 6 and 6C, public surrebuttal testimony and confidential surrebuttal testimony Exhibits 9 and 9C, and the errata sheet Exhibit 10.
Would there be any objection to the exhibits as listed by Mr. Zobrist? Seeing none, then I will admit Exhibits 3, 6, and 6C, 9 and 9C, and 10.
Thank you, Judge, and I tender Ms. Messamore for cross-examination.
Is there cross-examination from Renew?
Yes, just briefly, thank you. Hello, Ms. Messmore.
Hello.
How did wind facilities perform during Winter Storm Elliott compared to past winters?
They performed better during Winter Storm Elliott than they have over kind of the average for the last 5 years. They also outperformed their accredited level and what we saw during Winter Storm Uri as well.
And can you speak to how Persimmon Creek performed specifically?
Similarly well, it's hard to scale it based on the SPP level data, but we did see strong performance from Persimmon Creek during that event compared to its accredited level of capacity.
Great. And are you familiar with staff's opinion on whether Persimmon Creek, is well suited to meet the company's need?
Yes.
Can you briefly summarize that?
They seem to imply there is no need, and if there is, Persimmon Creek is not the way to meet it.
Do you agree with that analysis?
I do not.
Can you explain a little bit further?
I think that Missouri West definitely has a need for both capacity and energy. The IRP was used to assess that need and identify the best resource plan to meet it, and Persimmon Creek was the best resource identified to fulfill the acquisition strategy outlined in the IRP.
Thank you. Those are all my questions.
Let me ask just a quick clarifying there, Ms. Messmore. You mentioned Winter Storm Elliott and Uri, or you were asked about them. Can you just tell us what those storms were and when?
Yeah, so Winter Storm Uri we're more familiar with. It's February 2021, I think roughly the 15th through the 19th of that month. And then Winter Storm Elliott is more recent. It depends on who you ask, but 21st through 26th of December 2022. So a pretty recent storm that was different from Winter Storm Uri in that natural gas saw outages in both, although less in Elliott than they did in Uri. Wind saw significantly more performance in Elliott than it did in Winter Storm Uri. And then coal actually performed worse in Winter Storm Elliott than it did in Winter Storm Uri.
Okay, thank you for that clarification. I'm sorry to butt in there. Public counsel, do you have questions?
Nope.
Staff?
Good afternoon.
Hello.
Piggybacking actually off the bench's question, so you're understanding that during Winter Storm Uri, that was the worst performing month, or one of the worst performing months that Persimmon Creek experienced?
I don't have the data to confirm that.
Okay. And who are you employed by?
Evergy, Missouri West. Technically, I'm at Evergy Metro testifying on behalf of Evergy, Missouri West.
And is it your understanding that Missouri West doesn't actually have any employees?
I don't know.
Okay. And is it your to your knowledge, has Evergy Metro responded to any capacity RFPs in the last 2 years?
Yes, they have.
Okay. And were they with West, or have they been with other utilities as well?
Both.
Okay. What capacity amount and price, do you recall?
That's confidential.
Okay. I hate to go in camera, but I think that might be the only way.
Judge, I guess I would like to have at least an offer of the relevance of what Evergy Metro was doing in an Evergy Missouri West case into this CCN.
Yes, if I can respond, up for the last couple of years, even though SPP treats and views the company on a combined basis, on an individual basis, West and Metro have had a capacity agreement that has been significantly less expensive for ratepayers than this wind farm would be. So a line of questioning asking, why that can't continue, or just ensuring that there is both the capacity and prices, I think, is relevant to both evaluating the need for this project and the economics.
I find the relevance of that highly dubious when we're talking about an Evergy Missouri West project that has been fully vetted at this point, and to go into confidential closed session to have offers of another utility, I don't understand the relevance. I think that in open session, we can talk about these issues of how Evergy, Missouri West is evaluated by Southwest Power Pool, as well as how it is evaluated with its affiliate utility. But I really don't understand the relevance of going into highly confidential market data, or pardon me, contract offer data at this point.
I do believe that Evergy itself has provided testimony in this case about metro capacity.
I think that's a different question. I don't have an objection to that.
Okay, I'm going to overrule your objection. I'm going to allow it. We can go ahead then. Do you have anything else or, okay. Let's go ahead then and go back in camera. public session. Now, are there commission questions for Ms. Mazamore? I know we deferred several things to her earlier. Commissioner Holzman, do you have anything?
No question, Judge. Thank you.
Okay.
Judge, I know that Chairman Roop had a series of questions. Is he available or not available at this point?
I will ask my questions, and then if we'll make sure we get his questions in there. So, but thank you. I'll just start with my questions then. I asked kind of the same thing. I don't know, were you here when Mr. Humphreys was testifying?
I was.
I asked him to kind of explain the difference between capacity factor and net capacity factor. Did you agree with his definition, explanation?
I did.
And did you also agree that the numbers you use referring to as net capacity factor and the numbers that he and even Mr. Lubert used, labeled maybe capacity factor, are pretty close to the same numbers?
I agree. Yes, I think we were using the terms interchangeably.
Okay. And for the purpose of assessing the true output of a generation resource, which would you truly use, the capacity factor or the net capacity factor? Which do you think is better?
Net capacity factor. But I don't know that anyone has put forward a true gross capacity factor in this case. Everything I've seen is a net view of net generation.
Okay. Do you agree with staff that Evergy Metro and Evergy West, I think we talked about this a minute ago, have a joint integration transmission service agreement?
They do. It's called Network Integration Transmission Service Agreement, or joint NITS.
Okay, so NITS for
Yes.
short, NITS. Can you explain the purpose of that agreement?
Yes. So essentially, it means that their resources are perfectly deliverable to each other, so their transmission service is essentially interchangeable, which the reason that impacts resource adequacy is it means that anything that is seen as firm service to Missouri West is also seen as firm service to Metro, and they can pass capacity between each other because they're perfectly deliverable and firm from a network transmission perspective. So that's generally what it means, and it also, that's how it applies to resource adequacy.
How long has that agreement been in place?
I believe 2015, subject to check, but it's been several years.
And is that agreement an SPP policy or requirement, or for both entities to participate in the SPP market?
No, it's not a requirement.
As a result of the NITS agreement, would you agree that Evergy Metro and Evergy West's resource adequacy requirement is assessed by the SPP on a combined basis?
By the SPP, yes. For the IRP purposes, no, we assess them separately.
Okay. Can you just explain why that is?
Yeah, so it fundamentally comes down to more of a cost allocation and ensuring that costs are appropriately spread across the two utilities. If we simply assume that Missouri West got to use Metro's capacity without paying for it in some form, then that would be Metro customers subsidizing Missouri West customers. So we always look at it, it's also lined out in IRP rules, and it's the way we've done IRPs historically to make sure we're balancing at the individual utility level.
do both Metro and West currently have a fuel adjustment clause?
Yes.
And, I'm sorry, did you say the resource adequacy requirements are assessed by SCP on SPP on a combined basis, correct?
Yes.
Yeah. How are those costs then treated through the FAC?
Sorry, which costs?
The SPP resource costs,
So we use our existing generation resources and any purchase power agreements or capacity contracts to meet our resource adequacy requirement. And so then the treatment of costs associated with all of those things are, as normally they go at either base rates or FAC, depending on what it is and timing.
so which entity benefits and which is penalized with the various, if you, well, let me re-ask that. If you, if they're treated on a combined basis, and you said in the IRP they were separated so that they wouldn't, so one wouldn't subsidize the other. Explain to me again the way the SPP treats it, so that the IRP is a planning document, right? But the SPP is actually the real costs and revenues flowing through there.
Right.
So how is it treated so that through the SPP process, one is not subsidizing the other?
Yeah, so in the SPP process, it's a compliance requirement, and so there really aren't dollars associated unless you get to the point where you're paying a deficiency payment associated with that process. So there's no costs associated with resource adequacy in and of itself. The specific resources that are being used to, sorry, can you stop whispering? Sorry, it's kind of background noise. The specific resources that are used are allocated not just through the FAC, but they're in the base rates of the individual utility that owns them. So Metro's share of IATAN 1 is a portion of the combined entities meeting their resource adequacy requirement, but Metro only pays for their share of IATAN 1, and Missouri West pays for their share of IATAN 1. And then they each get the corresponding energy and other revenues from SPP that goes along with their ownership share. Does that help?
Yes. And IATAN 1 is a coal plant.
Yes.
And is Evergy West short of capacity?
At this point, we are expecting our short position, absent buying other capacity, including Persimmon Creek, would be next summer, 2024.
And
This is a mess. She's starts planning with energy.
are you familiar with Mr. Lubert's testimony?
Yes.
And in his testimony, he had a highly confidential figure 3, which was a production and load graph in his rebuttal testimony.
What
It's on
page?
page 48.
Okay.
And I think also that the graph is confidential in the numbers, and let me just ask Evergy, are the trends in that graph also confidential?
Well, I'll defer to Ms. Messamore to tell you that, Judge.
No,
Okay.
I don't think so.
Okay.
So the graph shows that demand is higher when production of wind is low and demand is lower when production of wind is high. During, at least during the summer months, is that?
That's the general trend. It is important to note this graph starts at 50 megawatt hours, so we're not, it's not quite as extreme as it looks. There is still a pretty good level of production even in that peak time. It's around, looks like 30 to 35% capacity factor even at peak. So while that is the trend, it is not like it's going to zero production during those high load times.
Okay. Is there a particular time of day when negative prices always or usually occur with, during certain months or seasons?
Definitely not going to say always. They typically occur more in off-peak hours and shoulder months. So shoulder months being non-peak months, the fall and spring.
So which months would those be?
That depends.
Which months are peak months?
So June, July, August would be summer, and then typically December, January, and February, winter.
Do negative prices occur at other times?
Yes, they definitely can.
Are there particular circumstances that you would expect them to occur?
Yeah, so when you think about locational marginal prices, there are three components that build those up. So you have your marginal energy component, marginal congestion component, and your marginal losses component. So I'll ignore losses because it doesn't change nearly as much. But from an energy perspective, that price is going to be set based on what your marginal unit is in the market. So if you were at a time where wind was the marginal unit at a negative price, then the energy component is what's driving that. So at very high wind, lower load times, you have that low marginal energy component driving a negative price. At other times, it can be driven by congestion. And so that's where it's a true transmission constraint that's driving dispatch that would be otherwise uneconomic if not for it's basically controlling around the capacity constraints on the system. So you can see that at other times where it's driven by maybe a transmission outage. It could also be driven by wind. There's a lot of different things that can cause congestion to drive prices either higher or lower than they would be if you were just looking at the marginal energy component.
Okay, looking at the IRP process now, has either Evergy Metro or Evergy West ever submitted an IRP that contemplates a merger between the two entities?
Not a merger, no. We do joint planning across the different utilities in our IRPs to assess kind of a broader view of, particularly given we have so many co-owned units, to look at things more holistically. But no, the IRP is required to be filed by the individual utilities, so it is.
In your SIR rebuttal at page 27, you state that the production tax credit expiration will be in 2028, correct?
Roughly, I think it's sometime in the middle of the year, just based on when the farm went in service.
In that schedule KM2, attached to that supplemental direct testimony, can you explain to me those, the various worksheets and what they're showing for the solar, it's labeled solar ITC?
Yes, so those are demonstrating the LCOE of some generic solar and wind. So not Persimmon Creek. Persimmon Creek is still in Witness Humphrey's schedule that you talked about earlier. So under different tax treatments, sort of pre and post Inflation Reduction Act. So the first tab, I think, and I apologize, I don't have it in front of me, so I'm going from memory. The first tab is a normalized ITC view, which is assuming solar takes the investment tax credit and it's normalized across a long term, which is the current IRS rules for an investment tax credit, so that you can't monetize it all up front. You have to normalize it across the life of the project. The second tab is the solar PTC that was implemented in the Inflation Reduction Act. So that's kind of the new option available under the IRA. And then I believe the third, fourth, and fifth tabs are the same general view for solar, but with updated cost assumptions. If you use some of the latest market comparatives around cost per kW install, all that changes in those tabs is updating the cost assumption based on those latest data points. And then the last one, I believe, is there's a wind view that uses a generic wind based on those market comparatives using the PTC 100% eligibility for 10 years as outlined in the IRA. Hopefully I didn't do those out of order and cause confusion.
I think you got it. So based on the assumptions that Evergy built into the model, how does the net present value of the revenue requirement for the three scenarios, the solar ITC and the solar PTC and the wind PTC, compare?
We were looking at it on a levelized cost of energy basis, so that's all I have off the top of my head. And that was included at page 25 and 26 of my supplemental direct. But even with the different tax credit structure available in the IRA for solar, it's still significantly higher than the cost of Persimmon Creek. And based on recent market comparatives for wind, they're also significantly higher, even if you assume 10 years of a PTC available for them.
And I think you touched on this a little bit, but for the solar ITC scenario, how are you assuming the investment tax credit will be applied? Is that a one-time credit?
No, it assumes it's normalized.
Okay. And what period of time is it normalized over?
I don't remember off the top of my head. I believe it's 20 years.
Is that on that schedule?
It's in there, yes. I can get it to confirm.
That's fine. And you said the IRS requires the normalization?
Yes. For utilities, not for all parties, but that's what would apply to us.
Judge, if I can interrupt.
Yes.
If the witness needs access to that tab, we can provide that to her if that would assist.
I think so far she's doing okay.
Right?
Thank you.
But if we reach a point and you need to see it,
I'll let
just
you know.
say so. What was the basis for the net capacity factor that was used?
For what resource?
For the, for Persimmon Creek?
That was based on a historical average capacity factor for the site for 2019 through 2021, so the 3 full years of operations at the time of the analysis.
And what was used in your scenarios that you ran?
Those were based on more generic resources, so I would have to check on to
Okay.
see what the assumption was.
Well, maybe if you do have that, Mr. Zobrist, or can we get her access to that?
We're looking for it, Your Honor.
Okay.
KM2?
I just have it on my computer, so.
That's fine. It's not what I have.
If she can retrieve her laptop, we can proceed, Judge. I mean, I mean, is it here, Ms. Mesmore,
Oh, yeah.
in the hearing room? Yeah.
Jay, do you have it? Pull it up.
Thank you.
Now we have to wait for my computer to start up, which is always an adventure. I apologize in advance.
That's fine.
I've put it through a lot. Okay, so for the different scenarios, the assumption for the solar capacity factor was based on a typical capacity factor we've seen from RFP responses, so that was a more generic option. And then the PTC is, or sorry, the wind scenario is around 50%, so about the same as what we've seen for Persimmon Creek.
And did you prepare a similar analysis for Persimmon Creek, calculating the net present value of the revenue requirement and the levelized cost of energy?
I didn't, but it's included in Witness Humphrey's testimony.
Okay.
There's no change to Persimmon Creek because of the IRA, so there's just the one scenario in that case that I used for this.
Okay. And do you know, based on your knowledge of Mr. Humphrey's testimony and so forth, was that information that would have been part of the work papers reviewed by staff or included?
Yeah, I believe it was attached as a schedule, actually.
On page 25 of your supplemental direct, you list the levelized cost of energy for Persimmon Creek, and there's a confidential number that I won't say.
Yes.
What assumptions went into determining that value?
It's the same assumptions from Witness Humphrey's schedule. So I think he already spoke to several of those.
Okay. And some of these are questions I asked him as well. Does Evergy West sell into SPP at a negative price?
Yes. It also occasionally buys at a negative price, which is confusing. So occasionally at the Missouri West load node, the price is negative. So we're actually being paid for the load that we're getting from SPP.
Okay. Can you explain the conditions or scenarios that would take place for that to happen?
Yeah, it's generally what I said earlier, where it's either wind is on the margin, wind, PTC eligible wind is on the margin, and as a result, your marginal energy component is negative, or there's congestion that's impacting the flow between the generator and Missouri West.
Okay, sometimes it may take 3 or 4 times before that soaks in that I have already asked you.
LMPs are not simple, so.
And do you know if Evergy West sells energy at a negative price, if those costs end up flowing through the FAC?
Yes, whether the price is negative or positive, what we get from SPP flows through the FAC.
Do the modeling assumptions shown in the scenarios in your schedule KM2 reflect how fuel and purchase power costs and revenues flow through the FAC?
All of the scenarios assume perfect rate making, so everything's assumed to flow through contemporaneously. There's no difference whether it's base rates or FAC.
Does the model take into account that that customers will be responsible for 95% of any negative price also flowing through the FAC then?
No, this model is not looking at the FAC at all. And the IRP also doesn't look at that because really it's just 95% of the difference in what happens between rate cases. So because we're looking at perfect rate making, it's not looking at that kind of division. And it wouldn't just be negative prices. It would be whether there's upside or downside compared to what's in base rates. That's where that sharing takes place.
And then with production tax credits, those don't flow through the FAC at all.
Correct. Those would flow through in base rates.
Those are in part of the company's taxes and and therefore, as you said, in base rates. So if that's the case, are the production tax credits applied? Do the customers get any benefit from those?
Once they're in base rates, definitely. Once the asset is in base rates.
Can you explain that a little bit?
So once the resource is put in service, customers would have the cost associated with the resource in terms of embedded in rate base, and then would get the benefit of the tax credit as part of the broader taxes that are leveraged or levied to customers. So it all just rolls through the base rates in totality.
Okay. Since the chairman has joined us, I'm going to let him ask the questions that he was wanting to ask, and then I may come back with one more before we're done here.
Okay.
So whenever you're ready, Mr. Chairman.
Thank you very much, Judge. I greatly appreciate that. I had several questions for you. For if they been keeping to you, I apologize. I had a phone call with the director of the department. I kind of had to take. So if you've already answered one of these questions, just tell me, and I will go back and read the transcript.
Will do.
And stuff. So let's see. What did I start with? Yeah, I was talking with Matt about, SPP looking at Evergy on a combined company basis, including Evergy Metro. So, and I know you've covered this in your testimony, but I'm an auditory learner. So why is it not appropriate for the commission to evaluate Evergy's capacity needs on the same way that SPP does?
Yeah, so I think I've covered most of that.
Okay.
I can hit, the quick short answer is it's a cost allocation issue of ensuring that Missouri West is paying for what they're getting from Metro from a capacity perspective. I also want to highlight in my rebuttal that I have the different views that show that on a combined basis, the view of their short position does not change. It appears at the same year with the changes that SPP has implemented. So it's somewhat of a moot point because the capacity need remains, even if you do assume they get all of the capacity available from Metro. But the cost allocation issue is the primary driver.
Okay. And so that I think I was asking Matt, like, so why should we not do it that way?
We would have to come up with a way to make sure that Missouri West is paying Metro customers for the use of their assets. They have historically done that through short-term capacity purchases, which is very different than all-in embedded costs of Metro's assets. So, like I said, it's a cost allocation decision. In the past, we have done it through competitive RFP processes where Metro has bid capacity to Missouri West.
All right. missed that one. I think I'd asked Matt about staff's viewpoint on the net present value revenue requirements is not the best measure of the low-cost option for meeting customers' energy needs, especially because they're saying it doesn't take into account the operational constraints of renewable resources. So I think I asked him to not looking at Persimmon Creek, just on the bigger picture. Do you believe that the Commission's IRP rule needs to be amended to address staff's concerns, or do you think it's not anything that should be addressed?
I don't think the rules need to be amended. The items staff has identified are primarily around historical LMPs at the Persimmon Creek node. And I've outlined in my rebuttal how that was factored into the IRP analysis. So I think there's sufficient room within the rules to address the items they're talking about in terms of market prices and forecasted market prices under a variety of scenarios.
And I think I asked him about, staff was talking about the inputs that you were used in the IRP process, to get the results that you want. How do you respond to that? And is it ever appropriate for utilities to select the inputs into an IRP?
We do ultimately have to select some inputs, otherwise the model won't run if there are no inputs. So we try to use publicly available data or data that's available with SPP in our IRP analysis. So we've done that. I think there was in opening statements a comment about the analysis being geared towards Persimmon Creek specifically, which doesn't make sense to me because the wind was identified in the 2021 IRP initially before we had done an RFP process or even knew about Persimmon Creek as a resource. So we worked through the IRP process, used publicly available sources or proprietary sources that we pay for to build the IRP, identified the need for wind, and then did an RFP process to select Persimmon Creek as the best wind option available to meet the need identified.
I believe I know it's been asked, I think it was by your company's counsel to Matt, but staff is saying that Persimmon Creek is not going to generate sufficient market revenues to cover its annual revenue requirement. And I think it's been asked, does Evergy West or Evergy Metro or for whatever, do you have any generation resources that produce market revenues sufficient to cover your annual revenue requirement?
Not market energy, not for Missouri West. I assume that applies to the other Evergy utilities, but I've only looked at it for Missouri West. The SPP market energy prices are not designed to cover fixed costs. They're built around a short-run marginal cost. So the market's not designed to cover all fixed costs, and it won't, other than in potentially extreme scenarios for a small period of time.
So the SPP Market Monitor has, for several years now, said that there's congestion issues in Missouri, especially kind of compared to some of the other surrounding states. How do those congestion issues impact, the ability to get, energy, from Persimmon Creek to Evergy people, and how does that impact, the prices, looking at SPP's refusal might be a strong word, but their reluctance to invest in transmission in Missouri?
Yeah, so let me make sure I don't miss any pieces of it. more mechanically speaking, we did assess the congestion risk and the market price risk of all the different wind sites that we got in the RFP. That was in Witness Humphrey's testimony. And so you can see that with that study, which is a production cost model factoring in transmission topology and changes over time, Persimmon Creek was the best option from a deliverability and kind of a congestion risk between the node and the Missouri West load. And so there's several ongoing transmission projects that continue to improve that position over time. So Sooner to Wakila is in Oklahoma. That's a large economic transmission project. Wolf Creek to Blackberry is another. And then longer term, the Joint Targeted Interconnect queue that SPP is performing with MISO will be a help as well. That wasn't factored into the assessment of Persimmon Creek and really doesn't impact it, but I do think that SPP is making good progress on starting to identify transmission solutions to this congestion, and that's part of why I outlined in my testimony that we use SPP's transmission models as the basis for our market prices, so we know what they're planning to implement and how they're planning to expand transmission capacity and know what impact that has on locational prices in our model.
In OPC's opening, they listed out a variety of power purchase agreements that Evergy has entered into, of which they believe have cost ratepayers money. Do you agree with their assessment on how they're calculating those?
No, I think it is too narrow in how it's looking at benefits. My understanding is that it's the PPA cost versus the SPP market revenues, which, as we've talked about, those are only designed to cover marginal costs and not all of the sources of value of a resource.
So could you make the argument, if you follow OPC's line of viewing, that Evergy has made poor choices on all their PPA agreements, so we're not going to do that anymore, we're just going to go buy a wind farm now because
Well, I won't follow their line of reasoning because I don't agree with it. But I will say that what they've done is look at kind of a retroactive view of, a hindsight view of those deals and have not actually done anything to assess the prudence of when they were signed. And so the same prudence standard should be applied in this case based on what we know today and how we've pursued or looked at the asset. Is this the prudent decision right now? So a hindsight view of other projects is not relevant in looking at the prudence of this decision, or the more directly to this case, the necessity for it.
I think Commissioner Holzman was asking the question, if you were to build a wind farm, what I think he was asking. I can't remember if he asked Matt or your assistant treasurer. What is the cost of waiting? Let's say we don't approve this.
Mm-hmm.
What are the projections on the cost of wind? What is the projections on construction cost of building something in the future? What is the declining value of RECs because there's so many more coming on there? What is the cost, in the company's position, what is the cost of waiting to find a better deal? Is there a dollar amount that you guys calculate?
No, not a dollar amount. I do outline all of the risks associated with doing that at the end of my rebuttal testimony. The last section focuses on it. From a construction cost perspective, since the IRA was passed, Inflation Reduction Act, we've seen increases in construction costs pretty consistently with the market comparatives that are out there. So that's one data point. I think there's still to be seen how much onshoring occurs, which can also drive up costs long-term, potentially, depending on how supply chains build out. REC's market is pretty highly illiquid and moves around vary dramatically as supply and demand changes. There's not a great forecast out there for RECs. But the short story is that if you did wait, you're essentially planning on a project that doesn't exist yet compared to one that's already in service and at a lower cost than the alternatives that we've seen on the market today, all of the alternatives. So that's more the risk of the project that's in service and we know the cost versus a future speculative where the cost is uncertain, the value of the RECs is uncertain. All of those things are uncertain.
So bird in the hand.
Yes, I hesitated to say that, but yes.
See, you finally said something, I'm like on the wavelength. So we had other discussions and questions with other witnesses, and I believe staff brought it up of, you're not actually fulfilling your whole capacity need. You're only doing 20 megawatts of the 170 that you need. So why not build a gas plant, especially gas prices seems like they're falling. Everybody I'm talking to is expecting below $2, and it's going to stick there for a while. So looking at declining gas costs and you're not being able to achieve everything that you're going to need, why are you considering this instead of a gas plant?
Yeah, so a few things. The latest 10-year futures I've seen still have gas in the $3.60 to $4 in MMBTU on average. So we have seen a subsidence recently, but the latest futures I saw on an average annual basis are still higher than what we'd seen back in 2019 and 2020. So that's one point on the gas price market and what the market expectation is. The next part around gas, I think it's important to remember that when gas is generating in the SPP market, it's typically the marginal unit. So that makes it the market price setting unit. And what that means is that when you have a natural gas generator, it's only going to be dispatched when the locational marginal price is equal to or greater than its short-run marginal cost. Its short-run marginal cost is in turn entirely determined by the gas price. So basically the gas price will move up and down, and whether your gas generator is generating or not, you're wearing that gas price risk. So either it doesn't generate and you buy off the wholesale market and you don't have any generator that's running, or it does generate and you're having to buy natural gas at that price. So I can do like a specific example of, assume I have a new combined cycle that's a 7 heat rate, so 7 MMBTU per megawatt hour, and gas is $2. The marginal unit in SPP is a 8 heat rate natural gas unit. So now my LMP, ignoring lots of other factors simplistically, is $16, and my price, short-run marginal cost for my gas generator is $14. So my margin is only $2. It's essentially the difference between my heat rate and the market setting heat rate of a gas unit. So when you compare that to wind, which has no marginal cost, there's a much larger margin opportunity, whereas with a gas generator, you're wholly dependent on whether your gas generator is more efficient than the marginal unit. And if it's not, it's just not going to run, and it won't be dispatched on. So that's one challenge with gas, where it's a great capacity resource generally, although performance-based accreditation will reduce the accreditation a little bit. But it's not a great energy hedge, because you essentially move your exposure to commodity prices from the wholesale market to gas prices for the actual fuel, if that makes sense.
And so you believe that with the wind, it's probably always going to be dispatched because it's going to be the least cost, so you don't have as much of a risk.
Right. Essentially, as long as the wind is blowing and your prices are above your short-run marginal cost, which for a wind is going to be negative grossed-up value of PTC, the wind will be dispatched. You're not as dependent on the commodity price.
Give me a scenario where wind would not be dispatched, where it would not be.
It would have to be congestion, transmission congestion.
Okay.
Yeah.
So if there's transmission, if there's not congestion, then pretty much wind is always going to be dispatched.
Yeah, when the wind's blowing, yep. And I'll make my last point, because it gets to what you're saying, is that it's not an either-or decision. I think the right answer is both, and we do have thermal resources in our resource plan. With recent changes in the capacity requirements at SPP, I could see some of those moving forward as we have a sooner and larger capacity need, but that doesn't change the fact that gas is not generally a great energy hedge. It's a great capacity resource. So you have to kind of balance across the two, and then solar is somewhere in the middle, so it will play a good bridge between those two resource types.
I believe it was in your assistant treasurer's, was discussing the 50%. I know in my head, I just can't articulate it.
Net
The
capacity
net
factor.
capacity, and that's NCF, is that what the acronym?
Yes.
NCF? Okay. So net capacity factor. Okay. That's all I had, Judge. Thank you for allowing me to get my questions in.
Thank you. And I just have one more clarifying.
Okay.
So earlier, we were talking about the production tax credits. And you said the benefits to customers begin from when the unit is put in service by the company. But is that correct, or does the benefit
I think
to
I said when it's
customers-
put in base rates.
It's put in, right, okay.
Yeah.
So the benefits of the production tax credits don't flow through until
Correct.
it's put in base rates?
Correct.
Okay. Are there any other commissioner questions that came up, just in case Commissioner Holzman had something? I don't hear anything, so I think that finally ends the bench questions. Is there further recross based on the commission questions from Renew? From Public Counsel?
I will grow one day, I swear. I do actually have a couple of questions. So, when you were speaking with Chairman Roop, sorry about that, I almost called you Commissioner, you discussed the OPC's concerns with past PPAs. Do you recall that?
Yes.
And you mentioned that you needed to avoid looking backwards in hindsight. Do you recall that as well? You said, I believe this is hindsight.
I did,
To
yes.
be looking, okay. So would you agree that the OPC bringing up these concerns at this point, raising them for Persimmon Creek right now, would not constitute hindsight?
I'm not aware of any concerns that OPC is raising in this context that are specific to Persimmon Creek. Instead, it's been a summary of the performance of PPAs, but no assertion of what is unreasonable about current assumptions.
Have you read the testimony from OPC, or is that just going off of the opening statement?
I've read it, yes. I've read Lena Mantle's testimony.
Okay. And you've read OPC and staff and what our positions have been?
Yes.
And you still believe that it is based off of?
Regarding the part about the PPAs, that's what I'm saying.
Right, no, I'm not talking about just the PPAs. I was just talking about if we, with Persimmon Creek at this point, if we were to address concerns that we have, and if staff were to address concerns that they have with the purchase of Persimmon Creek, would, if it comes up again in a future case, would it still be considered hindsight?
I think it depends on whether I don't know if we're talking about prudence or we're talking about a CCN. So I feel like I'm getting in legal area right here. I would say that the concerns that staff and OPC have raised relate to the need for the resource and whether Persimmon Creek is economically feasible in order to meet that need. Don't know that that gets to anything around actual prudence.
Right. And I, sorry about that. So you talk about how we talked about the economic feasibility. So if we in future bring up the issues again, or if we continue to speak now about our concerns with the economic feasibility of this project, is that speculation or hindsight? When would be the appropriate time to speak about those concerns?
Well, Judge, I think there are about three questions there. It's compound, I think it calls for speculation, and it calls for a legal conclusion.
I was just trying to see if it would be okay for us to discuss economic feasibility, which is one of the tartan factors, if that is a hindsight issue, as she stated in previous testimony.
I'll allow it.
You're going to have to rephrase the question then.
Okay. So we are bringing up, OPC has brought up, you discussed OPC bringing up the economic feasibility as one of the issues that we had with the Persimmon Creek project. Are our issues concerning Persimmon Creek hindsight, or given that it's with the past performance of Persimmon Creek?
Judge, I really don't know what we're referring to. Is this Ms. Mantel's testimony? Is this Mr. Seaver's testimony? What is the point of reference in this question? I think it is confusing and vague and ambiguous.
The point of reference is what was the conversation that she had with Chairman Roop, where she was talking about how our determinations were based on hindsight, and we need to avoid hindsight. So we're asking if our discussions currently regarding the economic feasibility of this project would be considered hindsight.
Pardon me. Pardon me, I'm sorry.
Were you finished?
Yes.
Okay, well, then, Judge, my objection is asked and answered, because the chairman asked about the purchase power agreements, the PPAs, and that's what Ms. Messamore responded to. So if there's something more specific than that, I'm certainly willing to entertain a question, as is the witness.
I'm going to overrule the objection. I think the question is still a little
confusing.
Yes, unclear. But I think that you're asking this witness's opinion about whether she considers OPC's concerns in this case to be a hindsight situation.
Yes. So basically, are you, with the concerns that OPC has raised regarding Persimmon Creek in this case right now, would you agree that those concerns that we are stating at this point do not constitute hindsight?
Judge, that clearly calls for a legal conclusion if we're relating it to the prudent standard, and I object.
And I'm responding to the fact that she was discussing about the hindsight of our assessment earlier on with that conversation with Commissioner Roop.
And I will overrule, while hindsight is a legal term, the witness was testifying as to what she thought was a hindsight situation. So I will let her answer. Do we need to read the question back?
Yes, please.
Would you agree that the concerns that are currently being raised by OPC about Persimmon Creek do not constitute hindsight?
I can't make any blanket statement. This is very long testimony. Is there a specific concern that I could focus on?
The economic feasibility.
I would say that, could you point me to the portion of Ms. Mantle's testimony you're referring to? that I see is referring to public interest and references staff's testimony, so I need to know what I'm responding to.
One moment. If you look at Ms. Mantle's testimony on page 6, the answer to the question, the question is lines 1 and 2. The response is lines 3 through 3 of the next page. And if you need a minute to read it, you can.
Yeah, I don't see anything about economic feasibility here. Are we still talking about economic feasibility?
Yes, because economic feasibility is the cost-benefit analysis in general, and it's not just economic cost-benefit, but it is all versions of the cost and benefit, which also includes, public interest in renewables, things like that. So the ability for it to be an economic hedge against the markets is one of the many determinations of cost-benefit that we discuss for economic feasibility and the Tartan factors.
Judge, is there a question pending?
Well, the witness asked her to clarify which topic she was discussing, so that's what she was doing. It's the same question.
Okay. In this paragraph specifically, there's some reference to the historical performance of Persimmon Creek as an operating asset. I would say I'm not going to call that hindsight, but it is based on historical information that wouldn't be available for other new resources. So I still think that the most effective or the most appropriate way to assess economic feasibility is through the integrated resource planning process, which is what we've done and have addressed or at least evaluated and discussed the concerns raised by staff and OPC in my rebuttal testimony.
Thank you. So to clarify your view, any analysis of past performance of any currently operating generation asset should not be taken into account when discussing whether or not to grant a CCN or to allow an acquisition?
I didn't say it shouldn't be taken into account, and it was taken into account.
I didn't say that you said it wasn't, but you said you look at the IRP, and you said that with any new asset, you wouldn't look at the historical data, but we have historical data here. Now that you have the extra information, shouldn't you utilize that information to analyze whether this is a good generation source for the purchase, for EMW's purchase?
We did use the historical information as an input into the IRP, which is the appropriate place to assess economic feasibility. Historical performance is not the appropriate way to assess economic feasibility.
Well, and it's, again, much like the IRP, it has several different different aspects to it. But I just wanted to say, if we are discussing concerns that we have, knowing, because we have this information, so OPC is discussing, and staff has discussed, concerns we have regarding the economic and engineering efficiency, generational efficiency of this source, and we're using past information. So would that be hindsight, or is that permissible to discuss and utilize in cases to grant a CCN?
I don't think it matters if it's hindsight. It's fine to discuss if it's an operating asset that has historical performance,
Okay.
which we've been discussing it.
Right, and are we able to, okay, are we able to, if we've now discussed these concerns that we have with this asset, in future cases regarding this asset, are we able to bring these concerns up again, or would that be also considered hindsight?
Judge, she's asking if OPC can bring certain attentions of the commission. I don't think this witness is in a position to respond to that question, so I object that it's improperly phrased.
Pardon, I have a more apt question. Was there an earlier point that OPC could have addressed the economic feasibility or other issues that we had with Persimmon Creek's acquisition into Evergy West, in your view?
This is the first case where we're discussing Persimmon Creek before the commission.
Okay.
Is that all?
One moment. Sorry, this is what happens when you're new. We are finished with this witness. Thank you.
Thank you. Does staff have questions, and are they extensive?
I don't know if they're extensive, but with how this has gone. If
I was considering a break.
Yeah, if we're debating a break, that would be acceptable to me.
Okay, let's take a 10-minute break until 3:30. We can go off the record. So we can go back on the record? Okay, we're back on the record after a short break, and we are ready for staff's further cross-examination based on questions from the bench.
Okay. Make sure I'm asking you the right questions. You had a discussion with the judge about the joint NITS agreement. Do you recall that?
Yes.
And I believe one of your responses was that although SPP may look at the utilities on a combined basis, the IRP does not. And one of the issues is cost allocation and wanting to prevent subsidization for the utilities. Would you agree that the capacity agreement that Evergy had in place previously addressed cost allocation and subsidy issues?
What do you mean by capacity agreement?
Between Metro and West.
For the term of that agreement, I would say it did, but it expires next year.
Okay. But there is a process in place.
Correct.
To do so. And is it your understanding, I believe you touched on a bit of this with Chairman Roop as well, about the cost allocations concerns, but is it your understanding that generation that's jointly owned is also allocated between the utilities?
I'm sorry, that generation?
Generation that is jointly owned is allocated between the utilities?
I'm not an accountant, but yes, that's my understanding.
Is it also your understanding that in rate cases, cost, which includes generation, are allocated both on a jurisdictional basis and for any wholesale or municipal contracts?
Can you ask it again?
Yes. Is it your understanding that in rate cases, cost, which would include generation cost or cost to procure energy, are allocated on jurisdictional basis since Evergy operates both in Kansas and Missouri?
Are you talking about the allocation between Kansas and Missouri or between Missouri West and Metro?
Missouri and Kansas.
I don't know about that.
Okay. Would you believe that there is a process in place to make sure that cost allocation and cross-subsidization does not occur between both Metro West and the Kansas, Missouri, and wholesale jurisdictions?
I'm going to need that one again.
Okay, I'll break it down. Would you believe that there is a process in place to make sure that there's no cross-subsidization and cost allocation issues are resolved so there aren't issues between Metro and West?
Again, not my area, but yes, I assume that's part of a rate case.
And would you also assume that holds true for, on a jurisdictional basis between the states?
Yes.
And would you also assume that holds true for any wholesale or city or muni contracts that are into?
That I don't know enough to say.
Okay. But it reasons to stand that there are processes in place to allow or prevent cross-subsidization and fair cost allocations that don't require individual generation being purchased.
In the context of rate cases, yes.
You were asked some questions about, again, with the Metro and West, if IRPs had ever been performed together, and you said no, but there has been joint planning. Do you recall that line of conversation?
Yes.
Is it your understanding that OPC in the past has proposed that Evergy study merging on a corporation basis the two branches in past rate cases?
Not personally familiar. I believe OPC's referenced that in other cases, though.
And if that merger happened on a corporate level, would that eliminate the need to do two separate IRPs?
I don't think I can speculate on that.
Okay, fair enough. At one part in some of your responses to the bench, you referenced perfect rate making. Do you recall that
Yes.
conversation? Is it your understanding that the modeling assumes that PTCs are immediately returned to customers?
The model assumes perfect rate making, so all costs and benefits are assumed to pass on contemporaneously, right away.
But Evergy is proposing or opposing the tracker that would align the perfect rate making to pass on part of those benefits to customers. Is that your understanding of the position?
I was not the witness on that issue.
You had some conversation with the bench about the hindsight, foresight differences and, you know, when it's appropriate or inappropriate to make adjustments based on what is known at a time. Do you recall that? I believe you also re-explored that with counsel for OPC.
I discussed with the bench the application of hindsight as it relates to PPAs in the past. I think that was the extent of that.
I believe in one of your responses to the bench, though, that you said staff isn't necessarily, in your view, raising a prudence concern. It was more addressing if the project is needed. Do you recall that response?
Don't believe that was a response to the bench.
Did you account for, or you discussed KM2 with the bench? Do you recall that?
Oh, KM2, yes.
And that relies upon the capacity factor to determine the expected annual generation. Is that correct?
Yes.
And that doesn't account for a reduction in expected generation after PTC eligibility expires, does it?
It does not.
Okay. I think that's all I have.
Is there any redirect?
Yes, Judge, a few questions. Ms. Messmore, you were asked from the bench and by counsel questions about Persimmon Creek's place in integrated resource planning. How would you characterize the role of Persimmon Creek in the IRP and the plans to address resource planning for Evergy, Missouri West?
Yeah, I would say the integrated resource planning process was done beginning in 2021 as related to this case. It identified a resource plan, which resulted in the selection of a resource acquisition strategy and an implementation plan. Once implementation began, that ultimately resulted in Persimmon Creek being selected as the best option to meet the need identified in the IRP. And then the IRP was rerun using specific Persimmon Creek assumptions, which then demonstrated the total benefits from an IRP perspective of $130 million.
And are other resources being contemplated in the IRP for the future?
Yes, definitely.
Okay. And what types of resources would that include?
In our current resource plan, it's a mix of wind and thermal and capacity contracts, market capacity contracts, as well as wind.
Okay. And when we speak of thermal, what does that mean?
Generally natural gas, we model it as natural gas.
Now, the chairman asked you some questions about the PPAs, and counsel for OPC did. Do you recall whether the commission reviewed the prudence of wind facilities in recent fuel adjustment cases, fuel adjustment clause cases?
Yes, specifically Rock Creek and Osborne in, I believe, the 8th prudence review. I'm not going to quote the docket number from memory. And then other PPAs have also been included in fuel adjustment clauses, which have been reviewed for prudence, although they weren't called out specifically in orders.
And what was the decision of the commission in those proceedings?
That Rock Creek and Osborne were prudent decisions in the context of them being long-term decisions.
And at the time that they were made, they were found to be prudent?
That's correct.
Okay. Now, you were asked some questions about cost allocation. Is that part of your duties and responsibilities at Evergy?
No, it's not.
Okay. Do you follow the integrated resource planning rules and what you do?
Yes.
Okay. And that's what you do as part of your current duties and responsibilities?
Yes.
Okay. Chairman Roop, I believe, talked about the price of gas moving down to, I think he said $2. Based upon recent information published by the Energy Information Administration, what is your understanding of the near-term projections of the cost of natural gas?
Yeah, from an EIA perspective, I believe they've seen for this year in the mid $3, so $3.40 to $3.60, I don't remember the exact number, and then continuing out to around $5 in the longer term.
And does the Energy Information Administration still consider that natural gas prices are volatile?
Yes.
Okay.
Yes.
Now, the judge asked you some questions, I believe, about capacity and energy. Now, my question is, in response to the points that have been raised, I believe, by the bench with regard to the marginal costs that are earned in the SPP energy markets and the PTCs, is that a basis upon which this commission should judge need or economic feasibility in this case? Based upon what the utility actually earns in the SPP energy markets?
No, wholesale market revenues are just a portion of the benefits of a project.
Okay. What is the purpose of the wholesale energy markets?
It's to do an economic dispatch and compensate resources based on that dispatch.
And is that meant to be a proxy or a substitute to what happens in a rate case when all factors are considered?
No.
Okay. You were asked some questions by counsel for Renew Missouri about Winter Storm Elliott. Do you recall that?
Yes.
Okay.
Thank you.
Do I get to have one? Thank you.
As a preliminary question, let me ask you, are you a member?
Objection, hearsay.
Okay, let me try to lay a foundation.
Let him ask the question first.
I was talking about for the exhibit, but,
I'm sorry?
oh, you haven't. You know, it's been a very long day.
It's fine, it's fine.
All right.
Are you a member of any of the committees at the Southwest Power Pool?
Yes, I'm a member of the Market Operations Policy Committee.
And are you aware of a report that was prepared in mid-January after Winter Storm Elliott with regard to the performance of the markets during that week of December 22 through 25?
Yes.
Okay. And Judge, I think this will be the company's exhibit number 12. Okay.
That's the correct number, yes.
Okay.
And is this confidential?
No, this is a public document. At a mid-January meeting of the Markets and Operations Policy Committee at Southwest Power Pool, was the performance of the utilities within SPP discussed about Winter Storm Elliott?
Yes, it was.
Okay. And are you familiar with that report?
Yes.
And does Exhibit 112 consist of excerpts from that report?
Looks like it, yep.
Okay. And is Southwest Power Pool the regional transmission organization to which Energy Missouri and the other Evergy public utilities belong?
Yes.
Okay. Now, what was the conclusion of this report with regard to the performance of wind generators during Winter Storm Elliott?
Yeah, I think they say it specifically, so let me find it. Yeah, so generally, the key points on page 9 include a comparison to Winter Storm Uri, which says there were fewer gas and wind outages, for example, but coal outages and derates were worse in Elliott. And then specifically related to wind on page 21, looks like. Accredited wind performed above Uri levels by about 9 gigawatts and looks like around the same number compared to their accredited gigawatts.
So if we turn to the final page, and it's actually page 11, but by the SPP logo, it says it's page 21.
Yes.
Let's look at Winter Storm Elliott. The first, or I should say, the blue bar, what does that mean when it says accredited?
That's how much capacity credit the wind resources get from SPP. So the proxy for Persimmon Creek is the 20 megawatts we were talking about earlier.
Okay. And the middle bar that's sort of a greenish color, it says 5-year availability, 10.8. What does that mean?
Yeah, that would be 5-year average megawatt generation across this period over the last 5 years.
Okay. And the 13.0 for available, what does that mean?
That was how much was actually available on average during Winter Storm Elliott.
Okay. And what does this document here conclude as far as performance of accredited wind capacity during Winter Storm Elliott?
It says wind far outperformed their accredited capacity level, where coal and gas underperformed their accredited capacity level.
Now, how did this compare with gas, which I believe is the previous page?
Yeah, gas in both Winter Storm Uri and Elliott underperformed due
I have
to...
an objection for relevance. We're getting a little off topic. We're not talking about what this particular wind farm is doing. We are now talking about wind farms in general. It's generalized. It's hindsight. It's not really relevant to what that issue right now.
Well, Judge, this has to do with the wind performance of Southwest Power Pool, which has been in discussion. It has to do with Persimmon Creek's performance, which is a wind asset within Southwest Power Pool that was operating during both Winter Storm Uri and Winter Storm Elliott, so I believe it's relevant.
Okay, I'll overrule the objection. Go ahead.
Okay. Did you complete your answer? I think we were talking about the relative performance of gas versus wind. If you could just summarize that quickly.
Yeah, so gas performance in both Uri and Elliott was below 5-year average and accredited levels, primarily due to fuel supply constraints.
Okay. And then how did coal perform during Winter Storm Elliott?
Below 5-year available, below accredited, and below performance during Winter Storm Uri.
Okay. So what did Southwest Power Pool generally conclude as far as whether wind performed better during Winter Storm Elliott than during Winter Storm Uri?
They concluded it performed better.
Okay. Judge, I offer Exhibit 12 at this time.
Would there be any objection to Exhibit 12?
Again, I will renew my objection for hearsay.
Staff has a objection as well. It's not for hearsay, but it appears that 10 pages of this presentation are missing, and unlike transcripts or data requests, this isn't necessarily something that staff has easy access to. So I don't think if the entire presentation could be provided, that we would have an issue with it, but I do get wary when it skips from 9 to 19.
Yeah, Judge, the whole presentation is about 30 pages. I have 2 copies, and I will be glad to give one to the bench at the conclusion of this witness's testimony, and then I'll either post or have copies available tomorrow, whatever folks would like.
Okay.
It is available on the SPP website. You have to search through the MOPC, the MOPC bar, which is not real easy to find, but you can find it.
I
so.
was trying to make Jay search for it. He was having a little bit of issue, but if you can.
Yeah. If I have an extra copy, I'll give it to you at the conclusion of today.
Let's, since we don't have the entire document at this moment, let's hold on rulings on allowing it, and I'll let you provide a full copy to.
I have one with me. If I give that to the bench, can I get it into evidence?
Do you need it in evidence right now?
Tomorrow morning is fine, Judge.
Okay.
I hear you.
Let's get everybody, let everybody have a chance to look at
Okay.
the whole document. I'll ask again for objections, and you can,
Okay.
we can
Okay,
take
fine.
care of it then.
Let me go back and look at my notes. I think I'm almost completed here. Let me ask you a question about the Inflation Reduction Act. I think you were asked a number of questions from the judge and perhaps by counsel. Did you analyze the benefits and detriments of Persimmon Creek both before and after the passage of the Inflation Reduction Act?
Yeah, the LCOE spreadsheet that I discussed with the judge was looking at the differences and comparative options versus Persimmon Creek. There's no impact directly to Persimmon Creek from the IRA.
Okay. So it didn't become negative or detrimental by virtue of the passage of the Inflation Reduction Act? All right. Did I miss any of your questions? Okay. One moment, Judge. Let me ask you one question about the joint capacity arrangement. If we look at Evergy Missouri West and Evergy Metro together, are they still going to be short in the near future?
Yes. The graphs in my testimony show that based on what was in the IRP, with the adjustments I outlined, they're actually short this summer. So we've made short-term capacity purchases that change that fact. But yes, they have a near-term capacity need expected next summer.
Judge, that's all I have. Thank you.
All right, then, that concludes your testimony, Ms. Bazemore, and you may step down.
And Judge, she has some other engagements. May she be excused from the proceeding?
She may.
Thank you.
Yes.
Thank you.
Okay, and that was Evergy's last witness, is that correct?
That's correct, Judge.
Then we can go ahead and begin with Renew Missouri.
Renew calls Mr. James Owen.
Can you raise your right hand? Do you solemnly swear or affirm that the testimony you're about to give at this hearing will be the truth?
I do.
Thank you. And go ahead with your, or if I've asked all the others to spell their names for the court report.
Certainly. Jamesowen. No S.
All right, since you've already stated your name, by whom are you employed and in what capacity?
I am the Executive Director and Officer of Renew Missouri Advocates.
And did you prepare and cause to be pre-filed surrebuttal testimony that has been marked as Exhibit 300?
I did. I don't have that exhibit mark in front of me, but I'll take your word for it.
And do you have any changes to make to your testimony at this time?
I don't.
If I were to ask you those same questions today, would your answers be substantially the same?
They would.
And are all of those answers true and correct to the best of your information, knowledge, and belief?
They are.
At this time, I offer Exhibit 300 into evidence.
Would there be any objection to Exhibit 300? Seeing none, I will admit that into evidence.
And I tender Mr. Owen for cross-examination.
And we sort of discussed on break. Does anybody have any cross-examination questions for this witness, Evergy?
Thanks, Your Honor. Good afternoon.
Good afternoon.
How are you?
I'm good. How are you?
Good. Just briefly, you were formerly public counsel, is that correct?
Yes, I was.
And in that position, did you find the filing of IRPs by the utilities that you helped to regulate, did you find that helpful in your job?
I did. I found almost everything that the utilities filed to be helpful in that position.
So how do the IRPs help you do your job as public counsel?
Well, I think, in a broad sense, it was really about trying to figure out what the future needs of the customers were going to be anticipated. Anytime a utility files anything, especially with an IRP, there's an issue of intent. What are they intending to do? What is their intention of how they're going to meet consumers' needs in the future? And to me, I think that is where it is most helpful, or at least from the perspective of a consumer advocate anyway, in order to be able to have that document available.
Thank you. Around page 10, around line 17 to 18, you testify that you believe staff is indicating its preference that utilities pursue plans that include adding a natural gas-fired power plant instead of renewables. Do you see that?
I do see that.
Could you tell us what you believe the benefits of adding renewables in addition to natural gas plants are?
Well, I think there's certainly going to be instances where gas is going to be an issue. I mean, we've spent a lot of time talking about Uri and Elliott this afternoon that I've listened to. Certainly one of the biggest challenges during those periods was with gas, was with issues with its reliability. When it freezes, it is a liquid source of energy. And so, in instances, and I would keep in mind Renew Missouri is not advocating for 100% renewable energy at this time. We do not believe that's something that utilities should be able to do. But having wind available where it can have benefits during cold weather incidences, or when it's hot and there's issues with coal plants, we believe that's important to have that as part of its portfolio.
Thank you. That's all I have.
Thank you. Are there cross-examination from public counsel?
No.
Staff? No questions, thank you. Are there any commission questions? We have commissioners both remotely and on the bench.
No questions, Judge. Thank you.
Thank you, Commissioner Holzman.
No questions, Judge. Thank you.
Oh, I heard a no questions, but it was very faint.
No questions.
That was the chairman. Thank you. All right. I don't have any questions either, so is there any redirect from Renew?
No, thank you.
Then your testimony is completed and you may be excused, Mr. Owen.
Thank you.
And that was Renew's only witness, correct?
Yes.
So we are ready then to begin with public counsel witnesses.
Before we begin with the public counsel witnesses, I did just want to verify about how late you were thinking about ending the hearing or the?
That's a good question. I was thinking we got kind of a slow start, but I was still thinking that we would conclude by 5. Am I seeing any objection or suggestion otherwise? Looks like-
No, someone just told me 4 is what I was going to say, but I saw a little internet thing that said 4, and you know how you have to believe everything on the internet. So,
Let me make sure our technician is prepared. You're prepared to go to 5, aren't you? Yeah. And our court reporter? Yes. So my plan would be then to conclude just a few minutes before 5.
okay.
So we'll
Sorry.
get as far as we can.
As far as we can, I believe in us. I think we can do it. Okay. Then OPC calls expert witness Jordan Seaver to the stand. I believe. No, I can't. Where's my paper?
Mr. Seaver, do you swear or affirm to tell the truth and the whole truth at this hearing?
I do.
Thank you. Can you please state or spell your name for the court reporter?
It's Jordan Seaver, Jordan Seaver.
All right. You can go ahead then.
Thank you. Okay, and I do know you already stated and spelled your name, so thank you for that, Mr. Seaver. Who is your employer and what is your capacity with that employer?
I'm employed by the Office of Public Counsel, and I'm a policy analyst.
Okay, thank you so much. Are you the same Jordan Seaver who prepared the rebuttal testimony for this case?
Yes, I am.
Okay. Do you have any corrections or additions to your written testimony as it has been pre-marked as Exhibit 200? I think?
I do not.
That's correct. And 200C, is that?
200 and
also-
200C, thank you. I'm very good at this. Okay. And if I asked you the same questions today that you had in that rebuttal testimony, would your answers be the same?
Yes.
Okay. Your Honor, I offer exhibits numbered 200 and 200C for admittance and tender the witness for cross.
Thank you. Would there be any objection to Exhibit 200 and 200C? Seeing none, then I will admit Exhibits 200, 200C. Is there a cross-examination from staff?
Yes, briefly. In your rebuttal testimony, you discuss economic concerns and also concerns related to curtailment. Is that correct?
Yes.
And I'm going to ask you to help monitor me and make sure I don't say any names of species that I'm not
Okay.
supposed to. So if you can, if I tried into HC, if you could please alert me. But is it your understanding that curtailment or any additional expenses related to potential curtailment is not considered, or was not considered as part of the LCOE in this case?
Yes, as far as I'm aware.
And do you know what the cost or the potential cost of those type of curtailment measures could be, or what kind of impact they could have?
I can't put a number on potential costs, but the consequences of such curtailments can be fairly severe, leading to curtailments at the times when wind facilities generate the most energy typically. So typically they're curtailed at night. If they're curtailed, this is due to, when we're talking about bats in particular, the habits of the bats, nocturnal, right? Wind facilities typically generate most of their energy at night, and the curtailments then align with the activity of the bats, which is at night, thus making the facilities, effectively useless at that point. And that's under, situations in which they're ordered to curtail because of bat take. Take.
And are you familiar with the operations of any of the other utilities, wind farms in the state?
Yes, I am. Some of them, yes.
Okay. And we're discussing, there's been quite a bit of debate over hindsight and foresight, but is there anything that you've seen that have happened with other wind farms that would lead you to believe that perhaps what has been estimated here could be worse in the future?
Sorry, I'm going to interject an objection. That's a speculation.
I don't believe it's speculation. I'm asking in his expert opinion if he's seen other issues and cases arise that could be comparable to issues in this case that lead OPC to come to the conclusion that it did in its testimony. I believe that's fully within his realm of expertise.
I'm going to allow the question overrule the objection.
So I am familiar with, and I don't want to venture too far into the territory, but generally the Ameren's High Prairie Wind Farm has been curtailed, and that is due to bat species take of bat species that are of conservation concern. And you're allowed a certain number of bats that you can take if the species is of conservation concern. And once you reach that limit, you have to stop. At that point when you're given this this warning, then you have to be curtailed once you reach that limit of bat take, and I think it's annually. So the reason generally that these wind farms are curtailed, and Ameren's High Prairie Wind Farm is an example of this, is because of their location near maternity caves for bats. And I now don't want to venture too far into the confidential information here, but I don't know. None of my testimony in this is confidential, if that helps.
Do you believe there's a way that you could finish your response without getting into the?
Yeah, I think so.
Maybe
I
on
think
a high
so.
level, and then if
So,
the commissioners want more?
Yeah, this is all public information. So the Oklahoma Department of Wildlife Conservation, as well as universities, other researchers, U.S. Fish and Wildlife have identified 4 maternity caves for a certain species of bat, and those caves happen to be in northwest Oklahoma, which is where the Persimmon Creek Wind Farm is. And the wind farm, I believe, is, it's in the same area as those. The certain bat population has large, they only go to these 4 caves in Oklahoma, and they have large populations that go there every year. If the take continues, if the take reaches a certain point, then we would see curtailments, which could be, again, have the consequences like High Prairie with Ameren.
And is acknowledging those risks and suggesting that there should be protection for ratepayers, or at least some sharing of the risk. Would you say that with the circumstance you know now, that would be a hindsight or a determination? Or do you believe it would be a looking forward with the information you have now?
Calls for a legal conclusion.
I believe we've had most every witness that's come through talk about hindsight and foresight. I'm not asking him what the prudent standard is. I'm just asking him on the basis of the information now, which a hindsight is a reasonable person standard, not a reasonable attorney standard. So if what we know now, is it reasonable to expect that there may be impacts with the information we have?
Then speculation as well.
Can you repeat your question for me?
I can try to maybe rephrase too, but as an expert in your position and using what is reasonable with what we know now, do you believe that looking forward, we can make a reasonable assumption on risk that could occur in the future?
Judge, I would also object to lack of personal knowledge. This is an Oklahoma-based facility, and I believe this witness only has Missouri knowledge.
I don't want to answer for the witness, but it sounded like he's reviewed Oklahoma knowledge, so I'm not sure if being in Oklahoma versus reviewing the information from Oklahoma makes a difference.
I haven't heard the witness testify. There's no foundation that he has knowledge about how the state of Oklahoma treats bats or any kind of hindsight analysis with regard to bats or whatever Ms. Murr's question is.
I'm going to sustain the objection. Ask another question, Ms. Mers.
If in a future case, disallowances were made because there had been curtailment, would you believe that would be a hindsight?
I'm sorry, same objections, Judge.
When we have prudence reviews, it's the witnesses looking at these things and making the disallowances and the determinations. It's not an attorney, we interpret the legal statutes, but not allowing a regulator to interpret the regulations seems absurd to me.
I think I'm having trouble understanding your question exactly, Ms. Mers. What is it that you're trying to ask?
Staff has been accused, and OPC, of making hindsight not predictions, that's not the right word, determinations on projects, and that is inappropriate. Staff is, in my question, I am trying to pose to OPC, if OPC has been criticized for making hindsight determinations, does he agree with a determination that when you know information now and in the future act upon that information that you knew 4 years ago, whenever, would he think that that would be hindsight as it's been lobbied at OPC and staff?
Is the reference point bats still, or not?
Well, in discussions with Ms. Messamore, we couldn't get a clear answer because there wasn't a firm point being taken to. It was apparently economic feasibility in general was too fuzzy. So now that a particular point is being brought up, the reference in this case is to bats, but I'm sure that if we look through, I believe Ms. Mantle has pointed out the 10 different IRPs which OPC has raised concerns in. So if bats aren't sufficient, we can walk through with Ms. Mantle her opinions on when she raised those concerns in those IRPs, if they were called hindsight, and if she would agree with that, if that's preferable to council.
I think we have ventured into basically a legal determination that the commission is going to have to make in weighing the evidence. So I'm going to sustain the objection. Let's move on from hindsight.
Okay, well, I have nothing further, but thank you.
Thank
Well.
you. Is there cross-examination from Renew?
No, thank you.
Is there cross-examination from Evergy?
Yes, thank you. Good afternoon, Mr. Seaver.
Good afternoon.
In your sir rebuttal testimony filed in this case, you stated that you were responding only to staff witnesses Lubert, Eubanks, and Lange. Is that correct?
I believe that's correct, yes.
And in your sir rebuttal testimony, you did not disagree with any of staff's analysis. Is that right?
Of the analysis that I stated, I didn't disagree with it, yes.
Is there staff analysis that you do disagree with?
I'm not sure.
Okay. In your rebuttal testimony, you did not do any independent analysis other than the staff analysis with which you agreed. Is that right?
I looked at staff's analysis and I found it convincing, and that's why I wrote the rebuttal testimony, yes.
And you did not do any independent analysis outside of that. Is that correct?
I did my own research as far as it went, but any analysis on the level of staff's, no. Or to
You-
the extent that staff did it, no.
You do not have a degree in economics. Is that right?
That's correct.
You do not have an accounting degree. Is that right?
Thankfully, yes.
You are not an engineer. You don't have an engineering degree. Is
That's
that right?
correct.
You don't hold degrees in environmentalism or conservation. Is that right?
Correct.
In this case, is it true that OPC did not serve any discovery or data requests?
I did not serve any data requests or discovery. I am not, I don't know about other OPC witnesses, which would be, I guess, Lena Mantle.
Sitting here today, can you think of any discovery or data requests that Ms. Mantle may have served on behalf of OPC?
I can't think of any, no, I'm not sure.
In your rebuttal testimony on page 2, you agree that EMW needs more capacity, including owned capacity. Is that right?
Correct.
You also, on page 7 of your rebuttal testimony, testified that utilities generally in SPP should increase their generating capacity. Is that right?
I believe that utilities in SPP will need to increase their generating capacity with the introduction of performance-based accreditation for capacity. And I don't know if I generally believe that utilities in SPP need to or should increase their generating capacity. I believe that Evergy Missouri West needs more owned capacity.
You agree that in the 4 years of Persimmons Creek operations, there have been no bat taking issues, right?
I agree that there haven't been any curtailments or any operational issues as a result of bat take. I wouldn't claim that there's been no bat take, there's been no raptor take, et cetera.
Is that because you lack knowledge as to whether there has been or not?
I'm not certain about the numbers of take of species of any kind.
Sitting here today, are you aware of any bat taking issues occurring during the 4 years of operation of Persimmon Creek?
Objection asked and answered.
It hasn't been, Judge.
I think she asked a slightly different question. You can answer.
Oh, okay.
I'm sorry.
Can you repeat the question? Sorry.
Sitting here today, are you aware of any bat taking issues occurring in the 4 years of operation of Persimmon Creek?
Any issues? No.
Thank you. No further questions.
You're welcome.
Okay, and just one clarification. When you say take and a bat take, are you referring to fatalities?
Yes, that's the term used by researchers in biology regarding wind farms in particular for any killing of an animal by the turbine blades.
Okay. Are there questions from the commission? Let me see if the chairman has any questions or Commissioner Holzman before Commissioner Kolkmeyer adds his.
No questions, Judge. Thank you. No questions.
Okay, thank you both. Sorry, Commissioner, go ahead.
No, you're fine. Thank you, Judge. Have there been other wind farms curtailed because of bat take?
Yes, there have. Which wind farms they are offhand, I don't know. I don't have that information before me, but yes.
Are they curtailed during a certain hour, time of the day? Did I hear you say that earlier?
Yeah, typically they'll be curtailed at night. Whenever the movement of the bats, or in cases there are curtailments due to bald eagle take, so whenever the movement of the species through the areas are the highest, they'll curtail. And for bats, it is at night, and that's also when the wind farms are the most efficient, when they operate the best.
Which my next question was going to be, where are the wind farms in relationship to persimmon? And if you're not familiar, you're not going to be able to probably answer that question.
Offhand, yeah, I don't know if I'll be able to answer that question. I mean, High Prairie is in northern Missouri, but that's not in
Okay,
Oklahoma
it's not
yet.
in Oklahoma.
No, and yeah, offhand, I don't know. I don't
Okay.
want to speculate too much.
Thank you. Thank you, Judge.
Thank you, Commissioner. Is there any further cross-examination based on the Commissioner's question, or questions from staff?
I just have one, I guess, further clarification based on what you were just discussing with Commissioner Kolkmeyer. Although the other wind farms you've referred to aren't in Oklahoma, are they situated in similar positions to other species of concerns that you believe makes them comparable?
Yes, so typically, the wind farms are sited in areas where the wind profiles are the best, obviously. They want to maximize the amount of wind that they can get, but that also typically tends to be in habitat for things like bats and raptors. For some reason, and I don't know why, I don't know if biologists know why, but the wind profiles tend to be very good near the maternity caves and the roosting caves, which are different. They use them at different times. Yes, so yes, in answer to your question, yes. You're welcome.
Is there anything from Renew? Evergy?
No, thank you.
Is there redirect from Public Counsel?
Yes, there is. So earlier today, and by earlier today, I mean maybe 10 minutes ago, you were asked about your credentials. Can you express what those credentials are and what makes you a worthy expert for the purposes of this hearing?
Yes, well, for the purposes of the hearing, in order to be an expert witness, I need to know more than the average person on the street about the topics. And I would say I know considerably more, not as much as I'd like, but considerably more than the average person on the street. My background in philosophy allows me to research arguments, make arguments, analyze arguments, and confusing, complicated topics. I'm not boasting, but fairly well. So I think those are together enough to make me an expert witness today.
Okay, thank you. So Evergy asked about your statement on owned capacity, on how there was a need for Evergy West to have more owned capacity. Do you remember that conversation?
Yes.
Can you talk about where your determination on owned capacity differentiates between Evergy West and their assessment of Persimmon Creek in particular?
So I agree with Evergy witness, Ms. Messamore, that there is a need for capacity in Evergy, Missouri West. And in my testimony, I referred to the prior testimony in other cases of OPC witness John Robinette, in which he clearly states that there is a need for owned capacity in Evergy, Missouri West. Where I think we differ is in the idea that Persimmon Creek adequately supplies that capacity. And this is due to many factors, not least of which is the performance-based accreditation that SPP is introducing, which will lower the accredited capacity for Persimmon Creek, which is already significantly lower than the nameplate capacity, which has been testified to already. And so I agree that there's a need for capacity, but I don't think that this is the way to meet it.
Okay. And you talked about performance-based accreditation, the switch from SPP's use of whatever they're currently using, which I can't come up with at the top of my head, to performance-based accreditation, and how it will cause Persimmon Creek's accreditation to go down. Can you explain that a little more?
Yeah, so in a presentation before the commission in, I believe, August of 2022, if I'm correct, SPP laid out the switch to performance-based accreditation and what that will mean for all utilities on SPP, but also Missouri utilities in particular. And the main takeaway is that the performance-based accreditation will take into account the past performance and outages and et cetera of a generating source. And that will either increase or decrease its accredited capacity. And because, as staff points out, Persimmon Creek has been not a particularly good wind facility, I believe that it will, based on the performance-based accreditation as laid out in that presentation, reduce its accredited capacity even more than it already is.
Okay. And do you remember having a conversation about curtailment regarding things that I am just nervous to talk about?
Yes, I do.
Okay, wonderful. So if Persimmon Creek is curtailed due to that issue, what effect would that have on the economic efficiency of that wind source?
I'm sorry, Judge. I don't understand the question, so I think it might be beyond the scope.
Can you repeat the question for me?
Yes. We were talking about the curtailment of I'm sorry, I'm trying to be pretty careful. Due to species, and I was wondering if he knew the economic efficiency, how that would relate to the economic efficiency of the generation source. Basically, the effects curtailment would have on the source, the wind resources, because they were talking about curtailment.
The what resource?
The Persimmon Creek, the wind farm.
Oh, the wind resource.
Yeah, sorry.
Does your objection still stand?
Could you ask it again? I'm so sorry.
Yeah. Do you have an opinion, and if so, what would it be for the effect future curtailment would have on the economic efficiency of this resource or any resource.
And
I don't think that I have a beyond the scope objection to that. I think maybe speculation now.
all right, I'll overrule and allow him to answer.
So, on the assumption that the siting of the facility leads to curtailments, and on the assumption that the curtailments are at night, which it's been established Persimmon Creek has the highest operation during, the highest generation output during, the economic performance of the facility would clearly be worse than it is now. At times at which the facility could operate the best, it would not. At times at which it would operate the worst, it would. There could be also economic consequences for ratepayers in the case of disallowances not given, or could be consequences for the company that would then be passed on to ratepayers. I can't see any positive consequences from economic or otherwise from future curtailments.
Okay, thank you so much.
You're welcome.
That's all?
Give me one moment to confer with council. We are finished with this witness. Thank you so much, Mr. Seaver.
You're welcome.
Thank you, Mr. Seaver. I should have interrupted earlier, but you mentioned that presentation in one of your answers. Do you know which presentation you were referring to?
Yes, give me just a second. Oops. So it was entitled, the document that was given was titled SPP Update, and it was it was given during an agenda, a commission agenda on August 31st, 2022.
The one that was marked as an exhibit today?
No, I actually just provided it as a footnote in my
Oh.
testimony. It's
Okay.
on page 6.
Okay, thank you.
You're welcome.
Okay, that concludes your testimony, and thank you. You may be excused.
Thank you.
Mr. Pell, we can also offer that presentation into evidence if you would like from OPC. Not right now, but.
Judge, just Commissioner Holtzman.
Oh, yes, Commissioner?
I just have one real brief question for the witness before you dismiss him.
Okay. He's coming back to the stand. Hold on just one second.
Yep, sorry, it'll be very brief.
Okay, go ahead, Commissioner.
Thank you. Earlier testimony, Evergy testified that the floor of the net capacity for this system was 10%, but that it could be in the 20s with the proper transmission and better performance. Do you agree that the floor of this is a net capacity of 10%, but it could have a higher ceiling? Is that something you agree with?
I have no reason to doubt that it's 10% currently. It could realistically be increased, but I don't see that as a great possibility for this facility in particular, given the introduction of the performance-based accreditation for capacity.
Okay, also earlier, it was established that Evergy could consider storage, and then in a follow-up question, it's not a part of this IRP, so that's established. But do you believe that if storage could be paired with this system, that it would drastically improve the firming of the energy available?
I'm not aware of battery technology currently that can provide that sort of firm delivery. I mean, it would be dispatchable. That's true, for the duration of that dispatchable energy is short at this time. And, furthermore, if we're talking about significant transmission upgrades in the future, we're also talking about an environment in SPP where large amounts of wind are coming onto the system. And because of the supply and demand that we have with wind, all wind on the system would see decreased revenues, and the value of the generation would be lower. And we can see with, bids in the system right now, and after the passing of the IRA, that there is significant wind development coming onto the system. So I do agree that if battery storage was applied to the Persimmon Creek wind facility, there would be a dispatchable source, but not one comparable to a gas plant, a coal plant, a nuclear plant, et cetera.
Do you agree with, this is my last question, do you agree with earlier testimony that it is about a 40% cost increase to build the same facility from raw land?
I don't have a reason to doubt that, but I don't know if that's correct.
Okay, fair enough. All right, thank you, Judge. Thank you for the question.
You're welcome.
No problem. Thank you. Hold on just one moment, Mr. Seaver. Let's see if there are any follow-ups. Is there anything based on the commissioner's question from staff?
No, thank you.
Renew?
No, thank you.
Evergy?
Briefly, in discussing accreditation with the commissioner, isn't it true that performance-based accreditation only applies to thermal resources?
By thermal resources, you mean?
Gas.
No, I don't believe so.
You believe it would apply to Persimmon Creek?
I believe that it applies to any generation source in a utilities fleet in SPP.
Okay, thank you.
You're welcome.
Is there further redirect?
Also, again, we can provide that presentation to Evergy if you need. But that, I do also have further redirect.
Go ahead with your redirect and I'll address that.
So what would adding batteries to Persimmon Creek do to the economics of that wind farm?
I suspect that allowing it to be dispatchable could allow it to be dispatched at times at which you might have a more favorable market for the energy. But again, the duration, as far as I'm aware at the time, right now, for battery storage like that is not long, and thus I would assume would not account for much of an increase in terms of the economic efficiency of it, or the economic performance.
Okay. Oh, 1 minute. Do you know how adding batteries to this generation source would affect rate base?
Yeah, it would increase rate base and thus increase the rates to customers.
Okay. Thank you. I also wanted to check Mr. Holzman, Commissioner Holzman, pardon me, asked if it was possible for the accredited capacity of Persimmon Creek to go above 10, I believe.
Yes.
10. And I want to kind of flip that question on its head. Could the accredited capacity to Persimmon Creek go lower, especially with the entrance of performance-based accreditation?
I am not sure if there's a floor to the capacity accreditation in the new scheme. So I don't know.
Oh, no. No, it's okay. I believe I am finished with this witness.
Thank you. And we do not need that whole presentation. I just needed to clarify which one it was. So I think this time you are finished, Mr. Seaver, and you may be excused again.
Thank you.
Okay, so it is about 20 till 5. I would like to go ahead and get Ms. Mantle sworn and get her testimony all taken care of and everything, and then maybe we'll end for the day at that point. Do you solemnly swear or affirm that the testimony you're about to give is the truth?
Yes.
Thank you. Could you please spell your name for the court reporter?
My name is Lena Mantle, Lenamantle.
Thank you. You may go ahead.
Thank you so much. And you have, much like Mr. Seaver, you have already stated your name and spelled it for the record, so I thank you for that. And can you let us know who your employer is and what capacity you are employed in?
I'm employed by the Office of the Public Counsel. My position is Senior Analyst.
Thank you. And are you the same Lena Mantle who prepared the rebuttal testimony for this case?
Yes, I am.
And do you have any, do you have any corrections or additions to your written testimony that has been pre-marked as exhibit number 201 and possibly 201C?
No, I do not.
Okay, perfect. Thank you so much. If I asked you the same questions that were asked in that testimony today, would your answers be the same?
Yes.
Your Honor, I offer exhibits numbered 201 and 201C for admittance onto the record, and I tender this witness for cross.
Would there be any objection to exhibits 201 and 201C? Seeing none, I will admit those exhibits. All right, let me just take a survey so we know where we're going to be. Is there cross-examination for this witness from all three parties? No. Staff
From
have-
Evergy, there is, Judge.
Okay, and staff has a small amount? Well, maybe we could go ahead and do staff cross in 10 minutes? No? No? Okay, okay. Well, in that case, we'll stick to the original plan then. And we can, is there anything anybody needs to discuss on the record before we adjourn for the day? Okay, I'd like to begin at 8:30 in the morning. We have kind of a chopped up day, but hopefully we can progress quicker maybe than we were going today. I think we will. So, thank you, Ms. Mantle, and you can come back in the morning. We can go off the record. Thank you.